Ladies and gentlemen, please welcome to the stage National Review CEO Chuck DeFeo.
Good morning and welcome. We are continuing National Review's series on and reflection of America's 250th anniversary. We call this our Lasting Liberty and Prosperity series. This series is born of the conviction that the American founding is not a relic to be admired from a distance, but a design to be understood, defended, and advanced in this moment in America's history. Today, we turn to a principle without which liberty cannot long survive: constitutional government. The separation of powers, the checks each branch holds against the others, federalism, judicial independence, and the impartial application of the law for every citizen. James Madison understood that better than perhaps any framer why this design mattered. Writing in Federalist 47, he warned that the accumulation of powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. That warning was not abstract. Madison and his fellow framers had studied history and history's failed republics, and they knew that liberty dies less often by conquest than by the show or slow concentration of power into a single set of hands. Their remedy was structural, not sentimental. In Federalist 51, Madison explained that the surest check on power is not virtue alone, but design. Given ambition must be made to counteract ambition. Each branch, he wrote, must be given the necessary constitutional means and personal motives to resist encroachment of the others. Among the three, the framers set the judiciary apart. Insulated by life tenure and undiminished compensation, precisely so that its judgments would rest on law rather than by design or the passions of the moment. It was to be, by design, the branch least tempted to bend to faction, and for that reason, the branch most necessary to a government of laws. We gather this morning because that design is being tested. For the last century, the checks and balances that the framers designed and the diffusion of power across the states has become more and more concentrated at the federal level. Courts and prosecutors have been drawn into the center of a partisan conflict. Proposals to pack the Supreme Court, end the filibuster, restructure the federal judiciary are no longer fringe ideas. They are openly argued as tools for the political advantage of the left. This morning's program, grounded in originalist reading of the Constitution, takes up these questions at every angle. Attorneys General John Ashcroft and Jeff Sessions will join Charlie Cook to discuss how the Department of Justice should function within a system of separated powers. James Rosen and Phil Klein will bring us through the work and ideas of Justice Scalia, the justice who did more than any modern figure to restore originalism and textualism to the court. Kristen Wagner will speak to the judiciary's independence and the recent victories for religious liberty and free speech. Casey Maddox, Ilya Sapiro, Charlie will examine the left's structural proposals and what they would mean to a constitution that we have inherited and have the responsibility to steward. And Paul Clement, one of the greatest Supreme Court advocates of his generation, will join Ramesh Ponnuru to reflect on recent victories and the ongoing challenges in defending the Constitution and the structure that Madison and the other framers put in place. Nearly 40 years ago, at the bicentennial for the Constitution, President Reagan captured what the document means to our enduring experiment and encapsulated what we will cover today. He said, "If our Constitution has endured through times, perilous as well as prosperous, It has not been simply as a plan of government, no matter how ingenious or inspired that it might be. This document that we honor has always been something more to us, filled with deeper feeling than one of simple admiration. A feeling, one might say, more of reverence. One scholar described our Constitution as a kind of covenant. It is a covenant we've made not only with ourselves, but with all of mankind. It's a human covenant, yes, and beyond that, a covenant with the Supreme Being to whom our founding fathers did constantly appeal for assistance. I give special thanks to our sponsors for today's event, the Peter and Judy Copsis Foundation and Wendy and Dale Brott, and I thank you all for joining us this morning. And with that, let's begin.
All right, can you hear me? Excellent. All right, well, I'm here with two attorneys general. I get to say attorneys general, which is one of those things you're taught in school, like Whoppers Junior, that you have to learn to get right. John Ashcroft and Jeff Sessions, welcome, gentlemen. I want to start this conversation right at the beginning. Often I do this on my podcast. I ask what is the most basic question. I'll start with you. What is the Department of Justice? What is the Attorney General? What should it be? Because this is something that people don't agree on. It's been around for, 170-ish years, and still we see arguments as to what its role should be, to whom it's accountable, and so forth. So what is it?
Well, the Department of Justice was created in, I think, 1870s in the Grant administration. It was begun to sort of harmonize and to oversee the U.S. attorneys who had preceded it since the Judiciary Act of, I think, 1789 right away. The Attorney General had been a part-time employee of the federal government for a long time, but the Civil War and the aftermath of the Civil War had found America with a sort of a plurality of interpretations as it related to the enforcement of law, and the Ku Klux Klan was a rampant organization. So I think all those factors came into being when the Justice Department as the department was created, and the Attorney General began a supervision in an effort to sort of provide, and there is a legal term which refers to the equal protection of the laws, but some level of uniform enforcement of the laws across the country. I think that's my understanding. I'm not a historian, but that's the way I think that's one of the roles, to make sure that there is not substantially differential federal enforcement. We expect a differential legal community in the various states because states have prerogatives to have different laws that they choose. But in terms of the federal government, I don't know that the phrase the equal protection of the law has been focused on the general public being protected by the law instead of perpetrators being protected by certain guarantees of fairness. But I think we all deserve some level of equity in terms of the way the federal law is administered across the entirety of the country. And that came up when I was Attorney General in terms of the death penalty. We didn't feel that the federal death penalty should be located only in states that also had the death penalty. We felt that the death penalty should be available as a tool of encouraging law enforcement across the entire country. So some level of equity and uniformity. I'm taking up too much time. Let me lateral this thing to Jeff Sessions, who's smarter than I am and is likely to score with a touchdown with the ball.
John is so great. He's remembered so respectfully in the Department of Justice, was a great Attorney General. We served together in the Senate. Well, when I was sworn in as United States Attorney, when Reagan appointed me, a young U.S. attorney, I announced that my agenda was to put criminals in jail and protect the United States Treasury. That's kind of a big part of what the Department of Justice does. And you have federal laws, federal criminal laws, which are the supreme law of the land, and every United States attorney advances that if they're doing their job. So so that's kind of a practical analysis of it. The Attorney General position, it was expanded over the years, and we have this the prison system is under the Attorney General and the Department of Justice, and all the FBIs and all that are part of it. So it's a monumental bureaucracy, and it one of the main things it does, it defends the laws of the United States against multiple assaults. When Trump was elected and I was Attorney General, we had this massive numbers of lawsuits against everything he was doing. One I still hold a grudge about is the immigration ban that Trump issued first day, and Sally Yates, I supported her staying on for a few days until I became Attorney General, and she refused to defend it. I'm still got a grudge about that. She didn't even say it was unconstitutional. She just didn't like it. And that is a breach, in my view, of responsibility. Your responsibility is to advance the agenda of the executive branch of which you are a part, not an independent judicial branch. It's an independent, it's a part of the executive branch, and it's your duty to defend the president's actions whenever you can. And if you can't, you can't. But that's the part of what we do.
And if you can't, what should you do? Because what should you do if you can't?
Well, in Britain, you would resign, right? And actually, I did resign, and Trump sent it back and said, rejected Make America Great. He wrote on my resignation letter. So we had 20 months of tense relationship. But fundamentally, he never ordered me to do something I thought was illegal. And I don't think he's, despite all his aggressiveness, which I supported. That's why I supported him early, because we had to break through, in my opinion, this stasis, this inability of Congress to act. Nothing ever could get done. We needed a strong leader. And so there's that tension constantly between protecting the rule of law and getting things done that need to be done.
So the Supreme Court just ruled in the Slaughter case that the executive is unitary in the sense that the president can fire pretty much anyone. There's an exception for the Federal Reserve, which will be litigated. But the argument here is that all executive power is placed in the president. And one of the responses that I read to this was, no, the Department of Justice, the Attorney General, they're independent. They're floating, some sort of fourth branch of government. They work for the people. They shouldn't be controlled by the president. What's your view on that?
Well, I think the Supreme Court got it right, because I think it's reference to the Constitution. The Constitution is a limiting document, and it limits various functions of government. It limits the legislative branch. It limits the executive branch in some ways, and it limits the judicial branch. And when these branches, when there's an overlap that sort of begins to confuse functions, I think returning to the Constitution is proper. I don't understand fully, and I haven't read carefully enough the decision to understand how you can accept the Federal Reserve without having, based on a Constitution which accepts nothing else. And, there is a fundamental thing. This is grade school. You can't amend the Constitution with a statute. And it could be a unanimous vote by the House and Senate, and the president could, before he signs it, put a nice piece of flannel on the table and have candles and light and everything, and he signed it, but it can't be done. and presidents can't give away their powers any more than they can extend the Constitution on the basis of some agreement with the legislature. There is a constitutional amendment. There are 2 constitutional amendment strategies that I know of, neither of which is satisfied. And so that, and the Congress is an interesting sort of, there's a little cognitive dissonance, I guess, between the way the Congress acts to give away its power to the bureaucracy so frequently, and then to say that it's then to be jealous if the president exercises his power more aggressively. But I think the Supreme Court is beginning to focus on the Constitution as the framer, meaning setting boundaries for the different aspects of government. And the fragmentation of power is the friend of liberty. And if you concentrate power in one branch or another, I think you risk the liberties of the American people. And for me, liberty is the single core value of human existence. Our founders talked about liberty all the time. They never mentioned democracy, really. And democracy's been stolen by the left. They're saying they're getting our democracy. Democracy is a process for decision making. It's how you make decisions. Democracy doesn't tell you anything about the outcome of the decisions. Liberty is an outcome. It's a condition in which humanity thrives. Democracy is a process, and of course, with your accent, I tell you might have a respect for Churchill, who said democracy is the worst form of government except for everything else we've tried. And I think that it's a good way to include everyone and get their viewpoints, but to put it within the framework and safeguards and limits of a constitution. And a constitution that fragments power the way ours does has been, over history, we've learned that it is to be respected because it has a durability and success that no other governmental form has ever enjoyed.
So one of the things we're talking about today is threats to this order. I'm not asking you to name anyone in particular, but there are different ways of looking at the role of the Attorney General, of the Department of Justice, of federal law enforcement. What do you worry about the most? Someone who will remain nameless becomes president in 2029, and they stand against what you would want to see the Department of Justice. What do they do? What is the big threat here?
That's a good question, because within the department, there were all kinds of long-established principles that may not have been absolutely required, but provide a certain stability in the law. And so I supported President Trump because he was saying we got to make some changes. We got to preserve this republic, and it takes some action, and I'm going to take the action. I thought that was good, but there's tension there, because stability is important. And so the healthcare guy gets murdered. So all these trillionaires, they better be defending the rule of law, because the populace might want to rise up if they're improperly led. So I do think that in the long run, it's the conservative principle, as William Buckley taught me reading National Review, to maintain stability and not undermine some important principles to achieve a short-term goal. So that's the tension. Like somebody mentioned the filibuster, we got a lot of, that can be reversed, can be ended. And it won't be a conservative thing, although a lot of conservatives want to eliminate the filibuster so they can do something good next week.
So what do you think of that? Because you came in as Attorney General under a conservative president who very quickly found himself at war. There's a paradox there, right? There's the need for stability, but then in wartime you have to be energetic. Did you find that a challenge, balancing between the two?
Fortunately, I think the framers of the Constitution made it possible for people to defend the Republic. And from the earliest cases, the cases that are anchored in my mind are the prize cases in the mid-19th century. But the ability of presidents to defend the United States from attack, certainly, or for assets of the United States. But very frankly, the president wages war. The Congress is said to be capable of declaring war. And somewhere between these two functions, with the Congress having the power of the purse, we have been able to negotiate our way through security challenges. And the declaration has become rarer and rarer. We haven't had a declared war since, it's my understanding, since World War II. So that means that the Korean conflict, the Vietnam conflict, the actions taken in the Caribbean and in South America or in Central America, and the actions taken in the Middle East have all been in defense of the national interest without declaration of war. And Truman considered the fact that we were doing this in conjunction with the United Nations somehow justification, and then that there were continuing appropriations, sort of an implicit consent by the Congress. So there's a lot of uncertainty here, but we've been able to navigate, should I say, as well as negotiate those positions between the Congress and the President in defending national interests pretty effectively. Obviously, those questions are emerging at the front of the public consciousness now, and there is a byplay between the Congress and the President. I think we need to, and there exists a certain consensus about national interest that results in a comedy between C-O-M-I-T-Y instead of C-O-M-E-D-Y. I mean, between the President and the Congress, which I think has served America very well, and it's been a durable service that's lasted now centuries. Congress declares war, but President wages it, but he has to wage it with some level of cooperation with the Congress, especially as it relates to the funding of the funding capacity, and the funding as technology elevates and skyrockets. It seems that the finance of the war is more and more critical to the ability of the President to wage the war properly. So constantly refining that cooperation between the legislative branch and the executive branch.
We have panels today on the Supreme Court. There are people in this country very upset with the Supreme Court. They want to abolish it or alter it. Some have suggested ignoring it. Now, you were Attorney General. There is a theory in American history, departmentalism. Thomas Jefferson sometimes talked about it, where he would say that each department should interpret the Constitution as they see fit, and if they don't agree with the Supreme Court, they should ignore it. What do you think would happen if an administration, an Attorney General did that?
It points out the critical need to have a Supreme Court that adheres to the Constitution. I think we failed badly in not defending the overruling of the abortion case by pointing out that the original ruling was not constitutionally based. It was an improper ruling. It wasn't a decision that I like abortion, you don't like abortion, I got 5 members of the Supreme Court, and I'm going to impose my will. So if we ever get to the point where the average American feels that the court is ruling based on politics, that's when the rule of law will be in its greatest danger. And I think it's probably served us well that the Supreme Court takes the role of being the final word on what the Constitution means. Although historically, I'm not sure. It's absolutely clear they have that power. So I think that's good. I mentioned, didn't mention before, I'll be brief, the Supreme Court ruling on the appointments says that you cannot create, Congress can't erode the power of the president by creating an agency that executes executive functions that encroaches on the president. So he can remove anybody that's in an executive role. So that was good. The same with this Chevron case, overruling Chevron, where the Congress passes a law, bureaucrats in the environmental section interpret it this way, and if it gets to court, the court says, well, that's sort of reasonable, we'll accept the agency, we'll give deference to the agency. But that is an abdication, don't you think, John? The courts ultimately are responsible to decide what that means and not some unelected bureaucrat.
All right, I want to leave some time for questions, but briefly before we do that, I want to ask you, are you optimistic or pessimistic about the future of the rule of law in America?
I'm optimistic. There are challenges to it. I have some, there are sore spots in my understanding. One of the things that I think executives have been willing to do is engage in what I call executive repealer. When an executive decides that they don't like a particular law, they suspend enforcement of it. I think that if we're going to repeal laws, it ought to be a legislative function. And the impetus for repeal ought to be, if it's an onerous thing to be enforced, then enforcement of it provides a part of the basis for, it happened with marijuana laws when I was, our U.S. attorneys wanted to come in and say they didn't want to enforce certain laws at a certain level. And I said, no. If the public doesn't like marijuana laws, it's not up to us to suspend the enforcement of the laws. So you ended up with a case that was, it ended up bearing Alberto Gonzalez's name, but it was a case that was brought during my opportunity to serve as Attorney General and didn't get announced until after I had left. But that was Gonzalez versus Raich. And this idea that certain of the laws will just be suspended by a president. Without naming anyone, if you were going to suspend all the laws enforcing immigration enforcement, that might, but that's rather, and that we've seen that, and it's a disaster as far as I'm concerned. And of course, in the ancient history, when I was Attorney General, Immigration Naturalization Service was all a part of the Department of Justice at that time. And we enforce the laws rather. So law enforcement is the responsibility, and any adjustments basically. And there's a difference between an executive repealer, where you say you're not going to enforce any of the laws relating to this, that, or the other because it's against your preference, and the idea of prosecutorial discretion, which is a case-by-case basis that we don't have the right kind of information, the right kind of case, the right kind of evidence, or justice would not be served by this particular enforcement. But the idea that the presidency of the United States is an opportunity to suspend all the laws you don't want to enforce invites a kind of discrimination which is dangerous, meaning you could enforce it against someone on an arbitrary basis in unique settings because it still is in force and effect, but you suspend it for all the people that you want to favor in some way because you think they might look favorably upon you at the next election.
But still optimistic.
I'm optimistic. Yeah, I am optimistic. I'm frightened by the idea that people are now publicly saying we want to not have a Senate, which is part of the fragmented power of the federal government. Fragmentation fosters liberty, and liberty is the core value of this culture. And you on the aggregation of power, putting it all together diminishes liberty. And I'm not a good historian, but I know something about the French Revolution, where the judiciary and the legislative were all rolled together, and they were some poor woman knitting stuff in somebody's, what was her name, Madame Lafarge or something like that, knitting your name in a scarf, and all of a sudden your head's rolling down the trough out of the guillotine. I mean, help us. We don't want to eliminate the Senate. We don't want to eliminate the Supreme Court. We don't want to eliminate states. There is sometime an appetite for a federal mandate of the states of what they can do and what they can have. When I was governor, we wanted to honor a provision of the Missouri Constitution that said judges retire at age 70. And when we decided not to pay the judges, they sued us. I think it's Gregory versus Ashcroft. We at least prevailed in the Supreme Court saying states have a right to have certain laws. So it's a frame of fragmentation that undermines the aggregation of power, which is a threat to liberty as far as I'm concerned. The filibuster rule in the Senate slows things down. And I'm sort of, I'm one guy who I'm glad I don't get all the government I pay for. I don't like the idea of waste and fraud. I hate, but the idea that I would get, well, I don't need a whole lot more government. That's
Are you optimistic or pessimistic about the rule of law?
I am. It's so much better today. When I was a young assistant United States attorney in the 70s, it was only Justice Rehnquist made sense. And now we have 6 originalists on the Supreme Court. Judges before that were just advancing political agendas under the guise of interpreting the words of the statutes and the Constitution. It was a direct threat, and it was undermining public respect for law as it should have. And with President Trump's nominees, I mean, they were great nominees. District courts, circuit courts, as well as the Supreme Court. So we've gone from just an outnumbered law school professor Supreme Court to principled conservatives who trust the legislature to pass laws, and then they see that they are fairly enforced. I'm pretty optimistic about it, but it can go fast. You get 2 or 3 resignations on the Supreme Court, and you have a socialist-type democratic agenda who refuses to accept failure to achieve their agenda now. Then they'll pack the Supreme Court, and if no filibuster, they can succeed in packing it with a majority. This is a scary thing, so it's fragile, but I am so proud of this court. I'm just, the DEI, so you got the executive branch rulings, you got this equal rights, as Justice Roberts said years ago, the best way to end racial discrimination on the basis of race is quit discriminating on the basis of race. And that is a huge matter. I mean, just monumental. And it's rippled all the way through the private sector as well as the public sector. So I'm pretty optimistic right now.
All right, do we have any questions? I think we only have time for one. Preferably keep it brief and don't start with this is more of a statement, really.
Yes.
It was on, we could hear you.
Hello? Oh, what do you think of the constitutionality of these district courts issuing, for example, a stay, which is then enforced nationally? So a federal district court judge can put a stay on some order, an executive order, and it's then supposedly enforced nationally. Is that actually constitutional?
Wow, that happened to us immediately in the early days of the first Trump administration, and I made a big speech about it, and they didn't like it, and I said, a judge one of 600 judges sitting on a pile of rocks in the middle of the Pacific Ocean can stop the entire government of the United States? But this is ridiculous. So yes, that went way too far. Justice Thomas and others have spoken out against it. You're getting much quicker reversals. Circuit courts are reversing these district courts on emergency basis much quicker. But I don't think we fully dealt with the impropriety. We called it non-party decisions.
Yes.
Because you in Alabama, you're not a party to the lawsuit in Connecticut. And the judges, so anyway, so you're right. It's a big danger. It's being curtailed, but it's still a problem.
You have thoughts on that, or should we get one more question?
I think Jeff Sessions is the kind of mind we need on the Supreme Court and the Attorney General's office. He's got this figured out, understood it, understands it, and speaks it clearly.
All right, we have time for one more question. Anyone else?
Within the unitary executive framework of the Constitution, what do you think about the Senate exercising its leverage to extract like a concession from the president or an attorney general nominee to wall off perhaps just criminal prosecutions to address concerns that people have about politicizing, especially criminal prosecutions from DOJ?
I think the president has a responsibility to make sure that the law is enforced. I think, we take an oath to support the Constitution and laws of the United States. The president, as a unitary executive, has a responsibility to do that. People ask me, does the president have a right to ask for the prosecution of an enemy of his? Oh, what if the president is the victim of an assassination attempt? And he's shot, but he survives. Does he have the right to ask the Justice Department to prosecute the person who shoots him? Does he have a duty to do so? If the president knows about violations that offend the law of the United States, does he have a duty to enforce that law through his attorney general? And this idea that somehow relationship between the attorney general and the president can be too close. I think of President Kennedy. Who did he have as his attorney general? He had Robert Kennedy. Last I checked, blood was thicker than water, to use an old Ozark phrase. I think the key is that we don't prosecute political enemies or friends based on their relationship in friendship or enmity politically. We prosecute people who violate the law. So when it comes to enemies, we prosecute public enemies because people who violate the law are public enemies. I think we have to be careful to have not to have differential enforcement. And one of the dangers of having incredible number of laws, and it's reflected in a book which I kind of recommend to you, although it does criticize me on several of its pages, is 3 felonies a day. The idea that with as many laws as we have, the average citizen may violate as many as 3 laws a day. And I've often said you could run a police state with 1 policeman if you had enough laws, so that you could identify someone you wanted to go after and just find a law they violated. So we need to be focused on crimes, not on people, so that we prosecute criminal activity regardless of their relationship to people in the administration. The fair administration of justice requires that. And one last thing, I know I'm over, but I think it's in the interest of presidents not to be too involved in who gets prosecuted, because we want them to be able to go around the country and not have their supporters or friends run up to him and say, Uncle Fred he was a supporter of yours, and why are you prosecuting him? I think so. There is some value to the president saying, look, that's not what I do. I don't make individual case calls on prosecution. We leave to the Justice Department. They tell me when they're going to, but they give me notice. They don't ask me for permission. And I think, the idea that somehow the president is asked for permission to prosecute on some kind of regular basis, given the number of prosecutions you have in the Justice Department, he would do absolutely nothing else. The Attorney General could do absolutely nothing else if he had to try and make a judgment on everybody against whom the law of the United States was to be enforced.
I think that's right, and but Bill Barr was clearly correct, in my view, to say that 2 wrongs don't make a right. I mean, the Russia probe went on, no matter what else you say about it, went on far too long. It was a duty of the Department of Justice to ensure that a cloud be removed as soon as possible from the President of the United States. I mean, this impacts his ability to be effective president. And I think that could have been concluded in half the time, in my personal opinion. And I still am not happy about that. And I think when I was prosecuting mayors and county commissioners and stuff, and when I was U.S. attorney, we didn't talk about it, and we brought it to a conclusion as soon as possible. And anyway, I think that's the way it ought to be done. So 2 wrongs don't make a right. And we need to get to it. We need to be very careful. We're not creating the impression that the rules no longer apply.
All right. Well, unfortunately, we've run out of time, so it just falls to me to thank former Attorneys General Ashcroft and Sessions. And the next panel will be up next.
Good morning, everyone. I'm Philip Klein, editor of National Review Online. I'm grateful to be here with all of you. To be honest, I wasn't the first choice, but Charlie wasn't up to assuming full hosting duties, considering England's spectacular, and I do mean spectacular, choke in the World Cup. Don't worry, everyone. I'm a Jets fan, so he has plenty of opportunity to make it up with to me during the football season. In all seriousness, thank you to Attorney General Ashcroft, Attorney General Sessions, and my colleague Charles Cook for that conversation. Events like this one matter because the questions we gather to discuss, the role of constitutional government, the rule of law, and the durability of our constitutional system aren't abstractions. They're the foundation of everything else rests on, and they deserve the kind of serious, sustained attention we're giving them today. I want to thank our sponsors again, as Chuck mentioned, the Peter and Judy Copses Foundation and Dale and Wendy Brott. We're grateful to have such committed and principled supporters behind our mission and our work. I'm excited to be facilitating this next conversation with a longstanding friend of NR, James Rosen. James has had a distinguished career in journalism and is an accomplished historian and author, as well as a fellow boxing fan. Most of you know him from his 2 decades of reporting at Fox News. He's written several books, including A Torch Kept Lit, Great Lives of the 20th Century, an anthology of essays by William F. Buckley, Jr. James has recently turned his attention to the great Antonin Scalia, writing a multi-volume biography of the late Justice. Copies of the second volume, which covers the years between his confirmation in 1986 and 2001, are available at the table outside this room, and it's the subject of our conversation today. Please join me in welcoming James Rosen. So, James, one of the things that you've had an advantage on against other biographers is being able to, I think of sort of Robert Caro toiling away in the Johnson archives. He never got to meet or interact with LBJ, but you spent a lot of time with the late Justice. What could you tell us about your interactions with him, and particularly, is there anything that you learned from being around him that would perhaps be less obvious than the public persona?
Well, first of all, I know this mic is not on. Well, let's make it work. 1, 2, there we are. See, I have marketable skills. It's great to be with you all. It's an honor even to be described as a friend of NR. It's such an institution that I venerate, and to be here with Phil, who is a cherished colleague. I see some familiar and friendly faces in the audience, and right now, for example, I can see Tevi Troy and Ilya Shapiro seated next to each other, and I'm brought what comes to mind is the quote, "Not since Thomas Jefferson dined alone." There's a lot of firepower in this room, and in the previous panel, of course, too. This was supposed to be a concise biography of Antonin Scalia. That's how it actually began its life. That was the contractual agreement. It was supposed to be the kind of book you can knock out on a long plane ride, and it would acquaint you with why he was important and why you should know about him. And just from my introductory remarks, I think you can all gather, as Mrs. Rosen certainly has, that I don't do anything concisely. And the more I looked into his life, the more, first of all, I found that he had been subjected to terribly unfair and inaccurate reporting, both on a day-to-day basis, but also in the 2 previous biographies of him. And I just developed more and more to say. The origin of it is that I watched him on television when I was a high school student on Staten Island, and saw him participating in this PBS program where it was a kind of a convening of eminent minds of the time from different disciplines in a theater in the round live studio audience setting, broadcast on PBS. And it was called The Constitution, That Delicate Balance. And they would be led through hypothetical scenarios by a moderator, an esteemed moderator. At that time, it was Fred Friendly, who was the nebbishy former president of CBS News and a longtime friend of Scalia's. Later, they would have various Harvard law professors as the moderators, and they would, and the eminent minds, I loved hearing the announcer, saying, that delicate balance, featuring Dan Rather, Sandra Day O'Connor, Gerald Ford, and they would debate, and so they would have like a ticking time bomb terrorist scenario. This was the 80s. And Dan Rather, how much of that are you going to report? Well, first I want to know what the facts are, and that sort of thing. And then just watching this as a high school student, I could see that Scalia was so fundamentally apart from the others. And I came to know Dan Rather, and I like Dan Rather, but Scalia had that outer borough sensibility that I have, that certainly all Staten Islanders share, that sort of chip on your shoulder. And he was sarcastic, and the fact that he had a sense of humor at all set him apart from everybody else. And I just found him compelling, and I said, someday I'd like to meet him. And when I came to Washington in 1999 to begin my career as a reporter here for Fox News at the time, Fox was so small and sort of unknown. It was only 2 years old that just acquiring credentials to cover events, we were constantly being asked, are you Fox 5? No one knew what it was. They didn't even have a Supreme Court correspondent, and I'm not an attorney. And I wrote him a note and said, I'd like to interview you. And there came a reply like 2 weeks later, which was how things moved in 1999. And he said, Dear Mr. Rosen, I had tried to assure him that, if he granted me an interview, it would be a dignified process, a fair product, and that we would even have fun. And he wrote me to say, Dear Mr. Rosen, on Supreme Court stationery, on the chambers of Antonin Scalia, it was a real thrill to receive it. And he said, I have no doubt, I am a fan of the Fox News channel. And that was so bracing to read from a Supreme Court justice. I ran and showed it to my boss at the time, Britt Hume, and we were both really jazzed to see it. And he said, I have no doubt that you would conduct a fair and dignified interview. I have no doubt that we would even have fun. He said, but I have a policy as a federal judge not to make a spectacle of myself, and I fear that an interview such as you propose would lead to that, and so, no hard feelings. Now, even though I wasn't a lawyer, I saw grounds for appeal. And I wrote to him and I said, Dear Mr. Justice, thank you for yours of such and such date. I certainly understand the premium you place on implementing your policy of not making a spectacle of yourself. However, what other than a spectacle would we call it when a sitting Supreme Court justice convenes in the presence of other eminent minds of the era before a theater in the rounds live studio audience and an entire battery of PBS cameras to debate hypothetical scenarios? And he writes back, and he says, Dear Mr. Rosen, again, the thank you for yours of such and such date, and he says, you are right, period. Right there, I could retire, right? I mean, there were this, probably 7 or 8 of the 9 children and 150 of the 200 clerkerati who never heard those words from the man, okay? You are right, period. He said, I probably should not have done the Constitution that delicate balance, despite the importunings of an old friend in Fred Friendly. And I had extended the off-ramp here of an off-the-record lunch, and he decided to do that. He said yes to that. And he said, you can come to the court, or you can go to the AV, he said, which is cheap. And the AV was the AV Ristorante Italiano, which is his favorite restaurant, now long gone, in what was then a fairly, let's just say, not the best neighborhood, it was a fairly sketchy neighborhood in Washington, D.C. And he'd been going there since the 50s, and it was a very modest place. They were like plastic grapes on the wall, okay? And, you might find cigarette ashes like on a windowsill or something. And so on the appointed day, which was Veterans Day, 1999, I arrived for lunch with Antonin Scalia, pretty much terrified because I'm not a lawyer, and, here I'm going to be in the presence of, one of the towering intellects of our time. And I got there first, and the way the place was laid out, it was a long chute and then the tables, and then even a still darker back room with tables. And it was a brilliant sunny day, and suddenly there's this silhouette, this sort of portly, jaunty figure that's coming through the front door, and suddenly it's materialized. That's Antonin Scalia is right there, and he's removing his jacket. He's complimenting me on my punctuality, which is a skill I've since lost. And my observation was that he had about him the kind of the the grandiloquence, the theatricality of a kind of a Jackie Gleason. You know, he was sort of like all sharp elbows, and I sat down. He wanted to know what, he's looking at the menu, and the young guy, was really from Italy. He barely spoke English. And Scalia says, "Pulpy, what is pulpy?" And the waiter says, "Octopus." Okay, and he says, "Octopus, I'll have the pulpy." And he hands the menu with a great Gleasonian flourish to the waiter. And now, you know, I'm very young. I've been in Washington, in relative terms, 10 minutes, you know. And I was very green. But I had interviewed some people of power. I was already at that point, like 8 years into my 17 years of work on a biography of Attorney General John Mitchell. I'd interviewed Gerald Ford, Henry Kissinger, all sorts of people. So I knew how to sort of handle myself with, you know, the high and mighty. And my one rule was, two rules really for this lunch was, number one, keep making eye contact and keep nodding to convey understanding even when you're utterly lost. And when you order something, make sure it's something that, you know, you don't eat with your hands. Nothing that will splatter on him or you, you know, something that's easily manipulable by knife and fork. And I come from Staten Island, which is 66% Italian. And, you know, I knew exactly what to order. I said, "I'll have the veal parmesan." And the guy's writing it down, and Scalia says, "No, give him the rabbit." And the two of us, the waiter and I, in our respective, you know, accents, say to him in unison, "Rabbit?" And he goes, "Yeah, you're gonna like it. Give him the rabbit. He's gonna like it." And the guy takes the menus and disappears. Now, I had never had rabbit in my life. I did not want rabbit. I was grossed out by the thought of rabbit. I haven't had rabbit since. But I had no choice. And so green was I that I really didn't even know if, like, rabbit comes served as with some courses of fish with the head still attached. I really did not know what to expect, honestly, you know, some cute little thing. So finally it comes, as you probably all would understand it, it arrives, and there was this dollop of green stuff, shaped like an ice cream scoop. And I didn't know what it was, and I made it a mental decision right then and there, like, do not touch that, whatever it is, right? And I'm nodding along, and he was so personable. He was so down to earth. He was, you know, he ordered wine. He's pouring wine for me. He's like, at one point, he's like, "Come on, have some of my vegetables." And I'm like, "Mr. Justice, come on. So, okay, like in a sitcom, I'm now like, you know, jolted into propriety. And there's 30-year-old me shoveling Antonin Scalia, Justice Scalia's vegetables, and, you know, hoping I don't drop them on their way to my mouth, you know, like mixed vegetables. And, you know, altogether, I was sort of lulled into feeling like I was hanging out with my avuncular Italian uncle, like a Paul Sorvino character. And I made points to sort of pinch myself figuratively and, you know, make sure I remained on my P's and Q's, because you're not in the company of your avuncular Italian uncle. You're in the company of one of the greatest, most towering intellects of our time. And there was a fortunate moment when he asked, "Have you read my book?" Which was the only book he had published at that point, a collection of his lectures called... it's a matter of interpretation, published by Princeton University Press. And I was in a position to say, yes, I had, and to discuss it knowledgeably. But, you know, here really what's most important is that you had the country's foremost opponent of judicial activism overruling my lunch order. And he drove me back to Fox in his car. He smoked cigarettes at the wheel and leaned on the horn a little too long at one point. You know, you could see a little flash of road rage. So I tried to keep the relationship going, you know, and I would write to him. I said, "Thank you for lunch. You know, let's do it again. It'll be my treat," as if he needed me to buy him lunch, but I figured that's about all I have to offer. And I get no reply. And this goes on for some months. And I periodically would write again, and I get no reply. And then comes what I call the intervening event. The intervening, that's a capital I and a capital E, Tom Wolfe style, the intervening event. And the intervening event was the publication of the May 2001 issue of GQ magazine, from the cover of which Ben Affleck in pale blue sweater and white slacks could be seen balefully staring at the reader. And right there advertised on the cover was an article entitled "The Partisan." And you open it up, and it is an account with a hideous caricature of Scalia, of an amusing correspondence and a pair of lunches that the author, a woman named Hannah Rosin, R-O-S-I-N, who was at that time the religion correspondent for the Washington Post, had with Justice Scalia. And I'm reading this, and, you know, aside from the scorned feeling of realizing that I am but one of many acolytes who, you know, have been treated to the AV, She trampled on the off-the-record stricture. One can count 14 quotes attributed to Antonin Scalia in those articles, from the letters and the lunches. And she had 2 lunches, one at the AV and one elsewhere. And I thought to myself, I'm never going to see this man again. And so I wrote him. And this time I wrote, I made some reference to GQ. And I get a response within a week, again on the stationery. And he says, "Dear Mr. Rosen, thanks for yours of such and such date. But I'm sure you'll understand if my taste for lunches with members of the press has gone sour, and I will retreat to my former seclusion. No hard feelings." And again, I saw grounds for an appeal. And I wrote, "Dear Mr. Justice, thank you for yours and such date." And I basically said to him that I considered that he was guilty of a knowingly injudicious application of sanction to offender and non-offender alike. By way of saying I played by the rules, and I said, moreover, I would like to think that I was just a fun guy to have lunch with and not simply a member of the press. And he writes back again. And he writes, "Dear Mr. Rosen," this time he dispenses with the formality of "thank you for such and such, yours of such and such date." And he begins with, "You really know how to hurt a fellow." He said, quote, "knowingly injudicious application of sanction to offender and non-offender alike," unquote, "is very good, period." Right? Again, I could retire right now. The entire clerkerati never heard this, right? And he said, "Moreover, I should probably try to avoid developing a psychotic aversion to all members of the press as opposed to a healthy aversion to simply most of them." And I wondered, is this the first time that the word psychotic has ever appeared on Supreme Court stationery? It turns out my research has subsequently found it is not. That there was an earlier letter by Scalia to someone else in which he used the word psychotic on his stationery. So we agreed to get together for another lunch, and we had one. And I wrote lengthy memoranda to the file about these lunches, chronicling what was said. But it was off the record, and I've elected to keep it so. But the story of the lunches and the correspondence is in the book you have in your hands, and it's in a chapter entitled "The Rabbit." In short, which I haven't been, he was so kind to such a green young reporter that I decided someday I'm going to write about this man. The only person who's, I would say, displeased with the fact that this concise biography grew into a second volume and now into a third volume, with the continual extension of Justice Scalia's lease on the lives of the Rosen family, is Mrs. Rosen. But I'm determined to see it through.
So early in the book, you quote something that Chief Justice Rehnquist once told Scalia, which was, "Nino, don't worry so much about the reasoning, just get the right result." Now, what struck me about that is that Rehnquist was no lib justice. I mean, he was one of the 2 dissenters in Roe. He was a distinguished conservative justice. And yet still, his approach was so much different to Scalia's. Could you talk about that?
Yeah. So first of all, it was a kind of a circuitous route to me learning that incident, that at the time, he would have been Associate Justice Rehnquist. When Scalia was on the D.C. Circuit Court of Appeals as a judge alongside a real murderer's row of judicial talent that at the time included Ruth Bader Ginsburg and Robert Bork and Larry Silberman and Kenneth Starr and James L. Buckley. They were poker buddies. The truth is that Scalia and Rehnquist, their careers are really tightly intertwined, and I make this point in the first volume. I considered one of my great archival triumphs that I uncovered a letter, an exchange of correspondence between Scalia and Rehnquist that occurred in 1971 when Scalia was general counsel to the newly stood up White House Office of Telecommunications Policy, where he needed an opinion, a legal opinion, about how they could proceed with their work from the Assistant Attorney General from the Office of Legal Counsel, who was Bill Rehnquist. And Rehnquist delivers the opinion that they wanted and needed, and with a little elan of his own. And then 6 days later, after that opinion is delivered into the hands of Scalia, and we have the courier actually noting the time it was placed in Scalia's hand, 6 days later, Nixon appoints Rehnquist to the Supreme Court. And, of course, Scalia followed him in that office of its OLC and so forth. I like to say that that opinion that Rehnquist gave Scalia in 1971, which had never been published before, is the only time that Scalia tasked William Rehnquist with authoring an opinion. But this was said to Scalia by Rehnquist when Scalia was rising through the ranks of the federal judiciary. And he said to him, and I interviewed Rehnquist 3 times for the John Mitchell book and for Fox News, but long before I began any work on this. But it's quoted from those interviews, and the idea that he would say to him, Nino, you focus too much on the reasoning, just get to the right result, is shocking, because it's precisely the opposite of Scalia's own approach, as Phil points out. And when they were nominated together, when they finally stood on the stage of the White House press briefing room with President Reagan and Warren Burger, as I say, titans all, Scalia can only have looked over at Associate Justice Rehnquist, now being nominated to be Chief Justice, and thought about their long entwined history, and thought about what he said to him. Just get to the right result. Don't worry about the reasoning. That was not the kind of justice Scalia intended to be. For Scalia, process was king, and outcome was very much secondary. And that is consistent with the approach of originalism, which is why Scalia is one of the most important Americans of the last 100 years. I put him up there with any inventor or Babe Ruth or anyone else you want to talk about. Because Scalia, through originalism and its chief tool, textualism, changed the way the law is drafted, argued, and decided in this country. And if you hearken back to the famous line of John Adams, that we are a nation of laws and not of men, that makes Scalia's accomplishment truly all-encompassing. There isn't a single American alive today who doesn't feel the impact of Antonin Scalia and the changes he wrought in how the law is done in this country. And to him, he was quite comfortable intellectually, if not viscerally, with outcomes that he abhorred that were the result of his rulings, such as his famous decision to join in the majority in Texas v. Johnson, the U.S. flag burning case. In this volume, there's the story told of his decision in Coy v. Iowa, which was a case in which a convicted child molester was challenging his conviction on the basis that when it came time for the alleged victim of his crime to testify, she was a very young girl, the authorities in Iowa placed a large non-see-through screen between them. And Scalia, with his love of language, textualism, ruled that the meaning of the Sixth Amendment, that you shall have the right to confront your accuser, shall and confront are non-negotiable. And confront, he went through Shakespeare and dictionaries, as he usually did, to find that confront means eyeball to eyeball. And while it might be very discomforting for a young assault victim to have to face her accuser, that's what justice requires. And that conviction was overturned by the Supreme Court. Now, of course, he abhorred the result. And as a matter of fact, my research found a subsequent case in which another inmate was able to get his conviction overturned for the same crime on the basis of Coy v. Iowa. But the difference between Scalia and Rehnquist, and what's most disappointing for Scalia, in fact, he was interviewed in 2013, and he asked, what was the biggest disappointment of your career? He said, Rehnquist's authorship of Morrison v. Olson, the 8-1 decision in which Scalia stood athwart the enlistments of special counsel. He said that was wrenching, that Rehnquist wouldn't get, that the executive power resides in the executive. The liberals on the court, Scalia always got along with great, because from his perspective, they all behaved as they're supposed to behave. Whereas his greatest disappointments were with his fellow conservatives. Rehnquist, from time to time, almost programmatically, Sandra Day O'Connor and Tony Kennedy, because he felt that they were always sort of placing their finger in the air and wondering what the New York Times is going to say about them. What will they get to the right result? But the originalist, simply as opposed to the living constitutionalist, doesn't feel that there's latitude in which for a judge, an honest judge, to determine on his or her own that the original text of a law or the Constitution can just be willy-nilly expanded to cover some modern-day problem or to incorporate the political predilections of the dishonest judge. And this was radical stuff, really, counter-revolutionary stuff when he started in the federal judiciary in 1982, but by the time he died, no less a figure than Justice Elena Kagan, appointed by President Obama, former dean of Harvard Law School, pronounced publicly that as a result, my words not hers, of this extraordinary counter-revolution in the law that Scalia championed, we are all textualists now. That is the heart of the change he brought to this country. That is why he's one of the most important Americans of the last 100 years. And as I say, there's not a single person you'll find anywhere on in this country who is unaffected by it.
So on that note, I mean, one thing that's sort of interesting is that during his actual time on the court, he was a lot of the famous opinions that we think of for him are actually dissents, right? But now, over time, his sort of philosophy took hold. So our conception of a conservative justice changed. We weren't thinking about, well, we need to have originalist justices back in the 1970s if you were a conservative, but he sort of changed the way we think of everything. And when I was reading the Dobbs opinion, I basically thought, oh, well, Alito's majority opinion was essentially the Casey dissent by Scalia. And so do you think that in some odd sense he's almost more influential now than when he was actually an active justice?
I don't think there's anything odd about it. I think this was very much envisioned by him. And he relished the writing of dissents because you don't have to worry about keeping a majority of 5. You could just swing for the fences and engage his literary gifts to their fullest. But I uncovered a letter which is included in this, a quote from which is included in this volume, in which he says, in essence, dissents are great, but it's better to win. But he, in writing those dissents and in infusing his opinions with his personality and with the great literary flair that he had, he was expressly playing to the future. He was open about this, saying in interviews that he wrote his opinions and particularly his dissents for the law casebooks at law schools. That if I write them in an engaging, sort of almost entertaining way, they'll be selected for inclusion in the casebooks, and then I will get to a subsequent generation of lawyer. And to promote this volume, when it came out in February, I published an op-ed, an essay in Politico, which drew on the interview that I conducted in chambers with Justice Alito in February of 2025. And for that article in Politico, I even published the photograph that sits in Justice Alito's chambers that he gave me for the purpose, that shows their first meeting, where it was not long after Scalia was appointed and had been confirmed and was seated on the Supreme Court, and he returned to New Jersey, his native New Jersey, for an event. And there was young Sam Alito with his name tag saying Sam Alito, shaking the hand of Justice Scalia. And I asked about Dobbs, and I asked about his jurisprudence in general, and also the fact that they were the first and second Italian-Americans on the court. And Justice Alito told me, the specific question I put to him was whether there was, in fact, as you were sort of just intimating, a straight line to Dobbs, not just from the dissent in Casey or Webster, but all the way back to Scalia when he was a professor, participating in televised AEI debates in the 1970s, where he denounced Roe on air as the embodiment of the imperial judiciary. Is there a direct line from all of those writings and speakings of Scalia's to Dobbs? He said, absolutely. And he said that he modeled Dobbs after Heller because he really wanted this to be an originalist opinion. And he even told me that he fancied to himself that if Scalia had written Dobbs, he would have written it this way.
Okay, I think we have a chance for maybe one question.
And we have a young lady with a microphone. There's a gentleman over here.
Back there.
Yes, so thank you for your reporting over the years.
Thank you.
Scalia really is the intellectual, as you put, godfather of the modern conservative court.
I did not use that term here, just for the record. But
Yes.
I won't quarrel with it, but I didn't use it.
And our previous speakers talked about the left's strategy for undoing his work, packing the court. Do you have a view on how likely it is that the left will succeed the next time they win a majority in getting rid of the filibuster and adding some new states and then packing the court, and on the potential value of a constitutional amendment like the Keep 9 Amendment that Senator Cruz supports in the Senate for preserving the current number of 9 justices?
I won't ask all of you to buckle your seatbelts, but I do want to provide the advisory that we've just been hijacked. Roman is an activist and whom I had the pleasure of meeting outside while signing books, and who leads an organization that is devoted to codifying that the Supreme Court shall remain at 9 seats. And so, rather than ask us about Justice Scalia, he's taken this opportunity to ask about my thoughts on that kind of work. Suffice to say, as I said to Roman earlier, I just think that it's almost tragic that we should even have to have that conversation. Is there another question, perhaps about Justice Scalia? Or about Phil? This means I have satisfied every last precinct of your curiosity.
So I guess just to jump in here, you mentioned, I mean, one of the sort of most famous cross-ideological friendships that we know of is the Scalia-RBG friendship. But one thing that's interesting, you alluded to it in your earlier remarks, but in the book you talk about how he had a very early falling out with Sandra Day O'Connor. So in the one sense, he's sort of very super close friends with the person he probably disagrees with in almost every decision, every contested decision, versus somebody who maybe he's 50-50 with. What can you tell us about that, and what does that tell us about his broader approach?
The relationship with Ginsburg, which is enshrined in stage plays and films and in all sorts of places, and which was very genuine, is treated in both volumes. In the first volume, when they were both together on the D.C. Circuit, I used her papers, which were open for that period, to show the exchange of memos and notes and even doodles between them, their 2 chambers, as they got to know each other and started this really great friendship. And you can see the friendship blossoming in their own words in real time. And then that's continued in Volume 2, where they do the opera together as extras on the set of the Kennedy Center and the stage, and they ride an elephant in India together 3 weeks later. And the country had never seen such a relationship between 2 Supreme Court justices and 2 individuals of such divergence in their philosophies, their gender, their religions, and everything else. The greatest friendship he had on the court was with Clarence Thomas, though, where there was a real brotherhood, and that is treated at some length in this volume, as is the rupture with Sandra Day O'Connor. One of my great archival triumphs in this book is in the photograph section, and it shows, and we devoted the whole page to it, a photograph that was taken inside the dark oak-paneled rooms of the Supreme Court on Halloween night, 1986, so really just a few weeks into Scalia's tenure as a justice. And he's standing there in a suit and tie, but with a red bulbous clown nose and a big smile on his face. And standing next to him in a sort of very professional-looking jacket and skirt is Sandra Day O'Connor, and she's wearing one of those giant Groucho nose and glasses mustache things. And as I say in the caption, it only went downhill from there, because Justice O'Connor enjoyed being a swing justice. And a swing justice is someone whose vote will determine which way the case goes. And with that status comes great power. But the key to becoming a swing justice is that you have to eschew the issuance, which was Scalia's preference, for bright line rulings that don't have any outs to them and which provide the kind of necessary guidance that the lower courts need to adjudicate similar cases without it having to bubble back up to the Supreme Court. And in Justice O'Connor's case, she, unlike Scalia, was a fan of various tools of construction that serve to enhance the power of the judge. which Scalia abhorred, such as balancing tests. Well, we decide that in this case there's 11 of the 13 conditions present, so we rule this way, but if we get another case that comes to us with a 12th condition present, we can maybe rule a different way, or we can keep ruling in incremental ways. That was anathema to Scalia. And he was able to expose Justice O'Connor for ruling in dramatically divergent ways just from case to case in the same field, whether it was accommodations for religious institutions or abortion itself. And in the end, he came to believe she just wasn't a very good judge, despite the historic significance of being the first woman on the court. That said, and there's a scene in this book that had never been reported before where the two of them are doing the Constitution, that delicate balance, okay, in 2007 after she's retired from the court, so he again returned to that program. And seated between them was my friend and longtime colleague, Judge Andrew Napolitano, familiar to many for his many years of dispensing legal wisdom on cable news. And he had never told this story before, but he was seated between them on the set of this talk show, this debate show. And the two of them were going at it so fiercely with each other that to the point where Judge Napolitano wondered whether the sound was being picked up. This was like, for him, the show within the show that was actually being recorded on the soundstage. And it got to the point where Scalia finally says to Napolitano, "You see what I have to put up with this woman?" And the name of that title is This Woman, which follows immediately the chapter devoted to the Webster case. So, but when she fell ill with cancer, Scalia was the only justice who she burst out into tears with on the phone and really unburdened herself, as recorded in her husband's diaries. I've interviewed her as well, I got to tell you real quick, I know we're out of time, twice for Fox News. And she was brittle. She had no sense of humor, no sense of give and take with a reporter. Bill Rehnquist loved to talk to reporters, you know, to have a cigarette and a beer and a cheeseburger and wanted to hear from the reporter what's happening in politics or whatever. But she was almost like the church lady from Saturday Night Live. One of the occasions for our interviews was that she had published a children's book and she wanted, about civics, and she wanted literally to read the poetry to me, you know, and I'm willing to put up with a little bit of that for the sake of the segment, but we've got to get to the news, which is the business I'm in. William F. Buckley once proposed in a column in 1978 that there should be a talk show Bill of Rights, which would guarantee that half of the available segment time is devoted to that which the subject wishes to promote and half to the subjects the host wishes to pursue. She had no grasp of this. And when I started to ask about abortion, for example, she almost ripped off the microphone. You could hear that scratching noise that comes with the attempt to remove it, and sort of pacified her. But I asked her one question that stands in memory, and I think this is a fitting, humorous way to end, which was, it was well known, as I said, it's well known that when you were at Stanford Law School, from which she finished third in her class and then couldn't get a job as a lawyer in that era, it's well known that you dated your future colleague on the Supreme Court, who I believe was first in the class, who was William Rehnquist. She goes, "Yes." And I said, "Now, on those occasions, did the Chief Justice show judicial restraint, or was he more of an activist?" Okay. And, "Oh, heavens, we went to a few movies and he was a perfect gentleman," she said. But on the side of the court, where there was a number of people watching these proceedings, I could see her husband, John O'Connor, tilted over to the side and holding his stomach. He was guffawing so heavily. So I consider it a win nonetheless. Thank you all for being here today.
Thank you to James Rosen. We'll now take a 10-minute break and see you all back here shortly. Welcome back. So one of the threads running through James's book is how insistent Scalia was that judges are bound by the text of the law, not by their own sense of what the law should be. That same question, whether the courts will hold the line or bend to political pressure, is exactly what the next few sessions will cover. As Scalia famously said, in his view, the principal role of the court in the area of civil liberties is to prevent the government from backsliding in its protection of long-recognized personal liberties. No group is ensuring this remains true more than our friends at Alliance Defending Freedom under the leadership of Kristen Wagner. Kristen is CEO, President, and Chief Counsel of ADF. Since its founding in 1994, ADF has been involved in a staggering 87 Supreme Court victories. Kristen will explain why the court's judicial independence and its protection of individual rights must remain central to the success of our constitutional system. Please welcome Kristen Wagner.
Thank you. It's great to be with you. This month we mark 250 years since Americans pledged their lives, fortunes, and sacred honor to uphold certain self-evident truths: that we are created equal, that our rights come from a creator, not the government, and that the government exists to secure those rights. Among them, the freedom to speak, to practice our faith, and to raise our families consistent with the values that we hold dear. Those truths were self-evident to our founders because they inhabited a moral world that was shaped by scripture and natural law. They recognized that liberty depends on virtue and that truth is written into creation and conscience. Those shared beliefs are what made the American experiment possible. I think the harder question, though, is ours today. Why are they no longer self-evident to some of our neighbors? And what will it take to see them clearly again? We can look at what has become of the free world that once took them for granted. In Finland, the Supreme Court criminally convicted ADF client and Finnish parliamentarian Päivi Räsänen under Finland's War Crimes Act for hate speech because of a booklet she wrote for her church on God's design for marriage. Later this year, in Britain, a judge convicted ADF client and military veteran Adam Smith Connor for silently praying for his son outside of an abortion clinic. This was the first thought crime conviction in modern British history. And today, Britain has arrested more people a year for speech that it dislikes than Russia. These countries are not distant dictatorships. They are close cousins among the free nations. But they are criminalizing speech and even thought. Many nations declare their rights, but ours, more than any other in modern history, actually secured them. And we've done so because our founders built a structure that honors the highest truth about human worth, while also recognizing that men are not angels, and majorities will trample the few. So they divided power. And they separated one branch from the daily passions of politics and made it a guardian of people's rights enshrined in law. That is the federal judiciary. For all of its faults, the judiciary, particularly the U.S. Supreme Court, has largely been a faithful guardian. The founders did not merely hope that the judiciary would be independent, they designed it that way. Alexander Hamilton understood why that independence was so important. In Federalist Paper number 78, he called the courts the least dangerous branch. No army, no treasury, neither force nor will, he said, but merely judgment. A judge does not sit to impose his will. He sits to say what the law is, not what he wishes that it were. And Article 3 gives federal judges lifetime tenure and forbids any cut to their pay for one reason: so that a judge can rule rightly and go home unafraid. Former Attorney General Edwin Meese, some have called him the father of modern originalism and a defender of the court, said it very plainly 40 years ago. The men who framed the Constitution chose their words with care. Those words meant something, and a judge's duty is faithfulness to that meaning, not his own preferences. And that is the source of the court's authority. Judge Robert Bork said judges either are bound by the text and original meaning of the law, or they are free to write their own convictions into it. There is no third option. And the moment we accept the second, the judge has stopped interpreting the law and has begun to rule us, which means the court's legitimacy and its faithfulness are one and the same. For a judge, holding the line is simply doing the work. As Fifth Circuit Judge Ho has recently urged, if you cannot accept the criticism and bear it, you are free to leave the bench. But if you take the role, do the job. So what is the job? Well, first, I would say it is not to fight policy battles. It is to faithfully interpret and apply the law, protecting the rights of a self-governing people to settle the hard questions for themselves, and to protect fundamental freedoms that are meant to sit outside of those majorities. This is why judicial courage must outweigh the fear of man, because the court is responsible to protect the freedoms that rest on the imago Dei, freedoms no majority can take away. And our tradition has a name for that. You know it: ordered liberty. Edmund Burke and Russell Kirk both saw that liberty is not license. It is not the enemy of order. It is actually the fruit of it. Cut freedom loose from order and it will slide into license, and license always ends the very same way, with the strong ruling the weak. Ordered liberty is freedom that is guided by law and sustained by the institutions and the people who are tasked with upholding it. Guarding it is a significant part of the court's charge. And I would submit it has done so, not perfectly to be sure, but consistently in 3 ways that I want to share today. First, the court often protects individuals across ideological lines, especially in unpopular views. Free speech and religious liberty exist precisely to shield the minority from the majority, and the court has guarded those rights for friend and foe alike. In 1958, at the height of the civil rights struggle, Alabama demanded that NAACP hand over its membership lists, a mandate that posed grave risks to the named individuals. And the court said no, and protected the NAACP's right to associate in private. Nearly 70 years later, in the first choice case that ADF argued this term, New Jersey demanded the confidential donor lists of group of pregnancy centers, an intimidation tactic that was pure and simple. The court again said no, 9-0. Different causes, different decades, different justices, but the same principle. The state does not get to harass or target people because it dislikes their beliefs. I have seen these principles play out repeatedly during my time at ADF, including in 3 cases that I argued on behalf of individuals where the government was trying to silence them and force them to express messages that they don't believe. And we won those cases, 8-1, 7-2, and then 6-3. This term, ADF represented a counselor that was barred from helping children confused about their sex to make peace with their bodies, while allowing other counselors to steer children towards social transition. We won 8-1, not because 8 justices agreed on the underlying issue, but because they recognize free speech is for everyone and viewpoint discrimination harms us all. Decisions like these help prove that the court is not a partisan machine. Nearly half of the court's decisions this term were unanimous. Only 23% of the court's decisions split 6-3, which is actually higher than the average usually. And some of those did not line up along predictable ideological lines. We can look at the birthright citizenship case, for example, 6-3, with Justices Kagan, Sotomayor, and Jackson in the majority. There are different reasons why justices cross the very cultural divides that are thought to bind them. Sometimes that happens because a justice sees how a ruling could be used far beyond the case at hand. The ACLU filed a brief in support of first choice this term because government investigations can point in any direction. Other times, a justice decides the constitutional principle outweighs the culture fight against it. Either way, though, we should recognize it takes courage, a virtue that we should want in every justice. Second, this is also a court and an institution that has been willing to admit and correct past errors. A body that could never confess error would not be a guardian, it would actually be a tyrant. In 1896, in Plessy, the court affirmed the lie of separate but equal. In 1954, in Brown, it rejected that lie and set the nation on a better road. In 1940, the court forced the children of Jehovah's Witnesses to salute the flag against their faith. 3 years later, in Barnett, the court reversed itself, giving us words that many know by heart. No official, high or petty, can prescribe what shall be orthodox in politics, in nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. In 1973, in Roe, the court constitutionalized a right found nowhere in the Constitution. In Dobbs, it admitted the error and handed the question of self-evident truth to the people. And in 1984, the court established Chevron deference, but 2 years later in Loper-Bright, 2 years ago in Loper-Bright, it overruled that doctrine. Thankfully, this is not a court that pretends to be infallible. It is a court that has the humility to correct course when it sees it has gone wrong. And third, this court protects its independence by staying within constitutional limits. It generally knows the difference between saying what the law is and saying what it wishes the country would become. It practices restraint under real strain because the other two branches have strayed from their original design. The executive has swollen far beyond anything the founders designed, and the legislature too often outsources its lawmaking to the other branches, trading real work for show votes and shutdowns. The court is forced into that breach, but more often than not, it is beginning to fill that breach by handing responsibility to where it belongs. Even the late Justice Ginsburg observed that the court wrongly froze the abortion debate over 50 years ago until Dobbs returned it to the people and their representatives. This term, in ADF's women's sports cases, the left asked the court to invent a new constitutional right for boys to participate in girls' sports and put the question permanently outside of the reach of voters. The court refused, saying that the state may recognize the real differences between the sexes and protect women's sports. Now, I admit, the court is far from perfect. Some critics will suggest that they use judicial restraint or the auspices of it to duck the hardest and some of the most important questions. And sometimes I would agree with that. But we also have to recognize that appropriate restraint is what keeps a court from becoming 9 philosopher kings. And of the 3 branches, it looks far more like what the founders intended than the other 2. But what makes it work is not only the framework, it is the people responsible for raising and selecting our judges. To be sure, the founders protected the court from direct accountability, but there is no doubt that we, the people, shape the culture, and the culture shapes the souls of those who will one day be judges. So too, the court's ruling shapes the culture. This is a cycle. The court does not sit outside the culture, judging it from above. It actually sits within the culture. And the law does not merely follow culture, it helps shape it as well. What it protects, people learn to honor. And what it permits, people learn to accept. Brown did not merely desegregate schools. It taught a nation that separate is not, in fact, equal. When the court protected Jack Phillips and Masterpiece Cake Shop, artists who declined to speak against their faith, it taught that the state may not force people to say things they don't believe, even if those things are not popular. When it said women's sports can be reserved for women, it taught that sex matters and can be recognized in the law. Think for a minute, can any of us imagine the country we would be in if those cases had gone the other way? Segregation, compelled speech, states unable to recognize legitimate biological differences? But the cycle runs the other way as well, and that is the danger. When the culture is captured and people cower, it can bend a judge's reading of a plain word. The law hasn't changed, but the water everyone is swimming in sure has. A word like sex meant something fixed and observable when legal texts like Title IX were written many decades ago. And it still retains that same meaning today. But when a justice interprets that word through an errant modern worldview, textualism goes sideways, landing on a conclusion detached from the law's intention and from the truth itself. Which is why the threats to this institution are so serious and so current. Violence against judges, campaigns to intimidate them, rulings mischaracterized by the media, officials who simply want to defy court orders they dislike. A nation that treats its rulings as optional, that cheers when they are threatened, that calls for changes to the court's time-tested structure, has already begun to abandon the rule of law. And without that, we have nothing left. This moment calls us to protect the judiciary. And that brings me back to us, to you. The courage and worldview of our judges are bound up with those of our people. This is true for several reasons. First, members of the court are drawn from among us. They are formed by us. Our judges are us. And they will only be as brave and clear-sighted as the country that produces them and the worldview that shapes them. Second, as fallible humans, judges are inevitably shaped by the worldview around them. Judge Ho has written about the myth of judicial supremacy, the assumption that our judges are morally superior guardians, when in reality the judge is an empire calling balls and strikes. But as he notes, even empires alter their calls to escape the crowd's booing. There's even a name for it, working the refs. Our culture is always working the refs, and the pressure on a judge is worse than on an empire. The crowd forgets an umpire by the morning, but the cultural elites know way too well how to boo a judge by name in a way that lasts a lifetime. Yuval Levin has said that when a judge bends to that booing, the bench stops being a mold and starts being a stage. But a healthy institution forms the person in it, and a sick one only shows him off. The same is true for family, church, school, university. Each was built to be a mold. But when these institutions stop forming us, they stop producing a people that are anchored in self-evident truths, rooted in virtue and formed in character. And they start producing judges who can't stand alone against a booing crowd, shaped by the applause of a moment. There's an old and haunting image for a civilization like ours today. It's a cut flower. It holds its shape and its color for a while, beautiful and seemingly alive. Yet cut from its roots, it will quickly die. Quietly as well. We are called to replant our civilization in the soil that first gave it life. But our founders warned us that this moment might come, that our Constitution was made for a moral and religious people, and that it is wholly inadequate to the government of any other. They placed their hope not in the wise few, but in the virtuous many. And they trusted virtue's formation not to the government, but to what Edmund Burke referred to as little platoons. Family, church, faith-based schools, voluntary associations, ministries, many of the organizations that we should be spending time in regularly. That is where we must place our hope for the future of the court, not only in the hands of those with elite credentials, JD, PhD, the honorable, and so on, but in those with the greatest credentials of all: mom, dad, grandma, grandpa, teacher, citizen. I was asked to speak today on the independent judiciary, so I'll give you my summary judgment of it all. The Supreme Court remains independent enough for now, and it remains the government or the branch of government that functions best. And yet our nation still wanders. Why? Because the court can protect the right to speak, but only we can stand for speech that is right. It can keep the door open for religious freedom, but only we can walk through that door. It can protect freedom of association, but only we can build associations that are worth belonging to. It can protect parental rights, but only we can raise kids who know the source of those rights. And it is up to us to do the work, to make what was self-evident once more. Because in the end, the court is simply an outgrowth of us as a people, and its judges come from among us, and their views are inevitably shaped and formed by the worldview around them. In the only sense that matters, then, the court will never be fully independent from us. So let us be what we want the court to be: wise, discerning, consistent, faithful, and virtuous. Thank you.
Thank you, Kristen, for that reminder of what's at stake. Our next conversation continues to expound on this threat, the growing willingness of the left to rewrite the rules of the game and across the other branches of government. Joining Charles Cook are Casey Maddox from Stand Together and Ilya Shapiro from the Manhattan Institute, two of the sharpest thinkers on constitutional structure working today. Please join me in welcoming Casey Maddox, Ilya Shapiro, and Charles C.W. Cook.
All right. So I want to start with a provocation, if you will. I assume, although correct me if I'm wrong, that we all agree that it would be a bad idea to pack the Supreme Court.
It's bad.
Right, that's bad. So instead of reiterating that at the outset, I want to ask both of you what you think would happen if the court were packed. Because the assumption is, at least on the part of those who want to pack it, that they would just add new justices and then they'd start getting their own way and everything would continue as normal. And I want to ask if that's true as a good starting point to what the threat is here. So I'll start with you, Ilya. Let's assume the court is packed and we add 4 or 5 new justices. What actually happens to the American constitutional order after that point?
Well, Charlie, and thanks to NRI for having me again. I really enjoy this organization and the magazine, of course. But this panel shows what dire straits we're in, because to discuss the Constitution and defending it and threats to it, they had to have 2 of the 3 people who were naturalized citizens. You can't even find native-born Americans to defend the existing structures. Nonetheless, what would happen? I mean, no one less than Bernie Sanders has already described this. This is possibly the only thing on which I've ever agreed with Senator Sanders. He, along with Joe Biden, were the only 2 Democrats running for president in 2020 who were against court packing. And I'm not going to do the accent, but he said, look, if we had, I think at that point 2, but now it would be 4, and then they take power, they keep adding, and in 50 years we'd have 87 justices. It's no good. So your question is, why is that no good if it's not facially obvious? And the answer is, it ceases becoming a court. It becomes another legislative body that just rubber stamps whatever their partisan side wants to do, which is also the reason why some of the so-called reform proposals are also non-starters. For example, there have been proposals to add, have a so-called balanced court, 5 appointed by Republicans, 5 by Democrats, and the other 5 by the previous 10. How do you depoliticize a court by adding an explicit partisan letter to at least 2/3 of its members? So no, this would be the end of the Supreme Court. It would be the end of constitutional governance, and I'm not one to go in for hyperbole.
Yeah, you have many of the claims from people who want to pack the court. First of all, you have the very express, like, we will achieve X, Y, and Z results, right, that Bernie Sanders would run through. I think the much bigger challenge, and Ilya hit on this at the end there, I think the much bigger problem and the reason why it's such a bad idea is just the complete evisceration of respect for the rule of law that would result. A lot of the folks who want to pack the court will try to make the case that the Supreme Court, there's this declining support for the Supreme Court, right? And so you'll see the polls that'll show you that we're in the upper 30s, depending on the poll, upper 30s, mid 40s, in terms of approval of the Supreme Court at this point. What they usually don't show you is that far outstrips the other branches of government, right? So, and the media and just about everybody else who wants to pack the Supreme Court. So, if you think right now, right, am I particularly proud of Congress? Do I think Congress is doing just a wonderful job? Most people would say no. That's what you get if you pack the Supreme Court, right? You don't end up with an independent court, as Kristen just described. You get a well-dressed legislative committee.
And just to put a finer point on that, you do, especially in the few weeks since the end of the term, always the polls, Gallup, all these news organizations have polls about the court. Public confidence at the court is not at a historic low. Sure, it's lower than it was 30 years ago, but it's higher now than, for example, right before the Dobbs ruling. I mean, you can quibble over the various statistical conclusions. The only thing that is novel and historic and unique and worrying is the partisan division. There's never been in that measure of public confidence for the court, which, as Casey said, is higher than any other institution of government, certainly, as well as other, media, other institutions, at a time of historically low societal trust in general. But what's really different is the difference between the public confidence among self-described liberals and Democrats versus conservatives and Republicans. Probably unavoidable given our polarized populist age.
So I just want to push a little more on this, because this is an actual proposal now that is not just 3 people. It's not just the DSA. It's something you hear all the time, especially during the last Supreme Court session. This was how every decision that institutional progressivism disliked was met. And I really want us to think through seriously what this would look like, because I have strong opinions on the meaning of the Constitution and on the rulings of the Supreme Court. But I also respect the institution of the court, so that when it does something I don't like, I say, okay, that is the court's decision, that's the law for now. Conservatives spent 50 years saying Roe was wrong, but they didn't say the rule of law is therefore dead. So just to push you a little bit, what would you personally do if the court were packed? Because my take on this is I would just no longer believe that its decisions were binding. I think right now, the worst thing that an executive could do is say, I'm not abiding by the law. I think that would be a constitutional crisis in this country. I no longer think that would be the case if the court were packed. Do you agree?
Yeah, that's right. That's right. I mean, at that point, right now we have these kind of false attacks on the legitimacy of the court. In fact, there's self-fulfilling prophecy. Oh, look, my friends and I are attacking the legitimacy of the court. That means the legitimacy of the court is in jeopardy. In that circumstance, it really would. It would destroy the line between law and politics. You would just have the same kind of legislators who would be 100% lawyers as opposed to whatever our current rate of lawyers in Congress is, 60% or whatever. And the decisions would be purely political. And we'd have to think about the whole framing. What would I personally do, you're asking? I don't know. Would I go into another line of work, or would I just be a talking head attacking the court?
I just more meant that, for example, I think the Obergefell decision in 2015 was wrong. Now, I've actually always been fine with gay marriage. I've never had a problem with it. I just think the notion that it is in the Constitution in that manner is wrong. Now, you disagree. I know we've had great conversations about it. The point
is, it's a question of occupational licensing, Joe.
I know. But the point is that when that came down, I said, all right, I think that's wrong, but that is the law, and I didn't want people to defy it in a way that I wanted them to defy any other parts of it. So I'm just asking you, would you personally just stop saying, well, that's the law now?
I would stop defending the court, and I would stop defending the court's virtue and legitimacy. This would be fundamentally transformational. The greater point here, though, and you might be getting to this in the end, is that the reason why the progressives, and increasingly, essentially everyone on the left, doesn't like the court or thinks it needs quote-unquote reform is because the court is finally pushing us back to constitutional governance. And the meaning of the Constitution is just at war with the progressive project going back to Woodrow Wilson.
Casey, if the court were packed, is that it? Would you no longer appeal to it? Would the executive branch have to follow its edict?
I would probably still follow the law because I like having my house and I like my kids, right? But yeah, I would be. There would be an increase or a decreasing number of us who would feel that way, right? And right now we wait at the end of the Supreme Court's term for its decisions, and we're happy about some aspects, we're disappointed about some aspects. I mean, Kristen was talking about this point that you'd have the court making decisions, and actually James Rosen, that you'd have the court making decisions, justices making decisions they disagreed with. Why on earth would a justice ever make a decision that they disagreed with in a packed court? You were literally placed on the court to change the results in the cases, right? And if you're making decisions that, if something needs to change, that's just another justice or two that needs to get at it. There's no reason why you have to vote against your personal preferences in any case, right? It's just a matter of a justice or two if we want to change the balance. So that's how decisions would come to be viewed. That we just have different levels of legislative committees, and I don't think that's a viable way for us to move forward as a country.
Do you think it's going to happen? Do you think this is idle talk, or are you gearing up to actually have this as a fight in the next few years?
Yeah, I mean, I think it is a very real threat. I think it's a very real threat that requires. I mean, look, right now, the Democratic Party is, not perfectly so. Fetterman exists, but the Democratic Party is largely, completely aligned on most things, right? And so, or far more so than the Republican Party, even now. And so, I think it is entirely plausible that once you get to, past 50 votes, that the Democrats could decide to eliminate the filibuster. And if you eliminate the filibuster and you have control of all three branches, or both the House and Senate and the presidency, I think it is a very real risk. They're sort of painting the expectation among their constituency right now for that possibility, and I think it's something that we have to take very seriously. I think if it's 52 votes in the Senate that they hold, and a bare majority in the House, maybe not, but it's been pretty recent, right? The Democrats have 59 votes in the United States Senate. This is not an impossible scenario where they could have the votes that could enable them to think, we have the power, we're going to hold on to the power, and so let's go ahead and use it.
Ilya, is this coming?
So Casey said a key thing, which is that they would need to get rid of the filibuster in the Senate. I don't think court packing would be the issue on which they got rid of the filibuster. They would do it on some budget bill, we have to protect health care, whatever, voting rights, I don't know, some other thing that they would get rid of the legislative filibuster, and then court packing comes and there's no more filibuster to deal with. And it becomes a very hard to resist political temptation. 5 years ago, 10 years ago, I wouldn't think that there would have been even 30 votes in the Democratic Senate caucus for court packing. Now that's higher, and those last 5 or 10, it's going to be very hard for them in an environment where there's no filibuster. They can't use that excuse for them to vote against it.
Unless Republicans do it for them. Eliminate the filibuster.
Right.
So what do you think about the public? In the great speech we just heard from Kristen, she made the point that ultimately this is a republic, and therefore, we need our judges, but we also need liberty to be valued by the people, our institutions to be valued by the people. When Franklin Roosevelt tried to pack the court, he had majorities that no one has had since.
Super
I mean,
majorities.
there were 82 Democrats in a Senate of 96. It's astonishing super majorities in both houses, and yet both houses wrote these extremely damning rejoinders to Roosevelt, saying this is the worst idea that's been proposed in the history of the republic. There would be a political...
His own vice president came out against it. 2 Supreme Court justices testified against it.
Right.
And at the subsequent elections, the Democrats lost 8 seats in the Senate and 82 in the House, thereby being reduced to just comfortable majorities rather than supermajorities.
Right. So there would be a cost to doing this. How confident are you that the public would be a part of that, or would this be an intra-Washington fight? Ilya?
Well, I don't think the public wants the court packed, but the Democratic base certainly does. The Democratic majority certainly does. And so just like Nancy Pelosi was happy to sacrifice her majority to enact Obamacare, I think this is something that the leadership would be willing to undergo.
You agree with that?
Yeah, I mean, I think you've seen for a while that the Democratic Party is sort of beholden to a small section of its of kind of one fringe of its base, and you're seeing now the Democratic Socialists sort of out themselves as kind of where they are on those questions. I mean, debating things like, should we just eliminate the Senate, and then calling that in the same Senate saying, I mean, I don't even think that's extreme to just eliminate the Senate altogether. I mean, that's sort of where they are, right? And it has been the case for a long time that the Democratic Party was moving leftward on a lot of these questions, and I think they're moving leftward because they are basically following where that kind of extreme wing is. So they have no difficulty in taking the 20 side of a whole lot of 80-20 questions, and I think this could very well be the next one of those.
All right, so let's talk about the filibuster a little bit, which would be a prerequisite to court packing, but is also important for other reasons. I am the very open president of the Filibuster Appreciation Society. There's about 8 of us. You guys can join if you want, bring it to 10. But one of the arguments that I hear, and sometimes from conservatives, that I think is worth dealing with, is the building we can see through that window has, to our disappointment, faded as part of our political system. The executive branch has got stronger. And so I will say frequently, this is a matter for Congress. Congress needs to, and the Supreme Court decisions that we often applaud essentially say, if you want to do this, to whichever branch of government is in the crosshairs, you need to legislate. And the filibuster makes that legislation more difficult. It raises the threshold. It makes it harder for Congress to act. Right now, Republicans have majorities in both the House and the Senate, but they still can't get through the majority of their agenda because the filibuster is in the way. And this is particularly annoying to some people at the moment who want Congress to pass the SAVE Act. It's a big debate in Washington. So what do you think of the argument that, yeah, there's lots of good things about the filibuster, but in a sense, the position I'm taking is inconsistent or hypocritical, because on the one hand, I say Congress doesn't do anything, and on the other hand, I'm devoted to this tool that prevents Congress from being able to act.
Yeah, I think it should be difficult for Congress to take trillions of our dollars and spend them on things we don't want or violate our rights. And I think we can too easily get caught up in this idea that, well, Congress isn't working. That's true, right? The question is, what would working look like? Almost everybody agrees they want Congress working again, right? The difficult
Make Congress great again.
That's right, exactly right. And we'll all sort of nod along, right? Left, right, center, everybody. Yes, Congress needs work, except maybe the DSA, who would just obliterate it altogether. But most of us would say we want Congress working again. The next question is, what would that look like? And I think it's not so much passing a series of bills, because frankly, I want more of that done at the state level, right? I am perfectly comfortable with California being weird and California-like, and New York being New York-like, if you allow for my home state of Alabama to be Alabama-like, right? And I think,
as far as I'm concerned, we're building a wall on the wrong side of Arizona.
That's right. I think we've got to get to that mentality. What that means for Congress is that the role of Congress is to be the place where the things that are national questions get debated and worked out. And you can still pass quite a lot of legislation if you are willing to give the other side the thing that really, really matters to them. Now, a lot of those compromises are things that I am not going to want, right? I bet that there are a whole lot of priorities that I want done through Congress that we could get Democrat votes for if it meant single-payer health care, if it meant national abortion access, if it meant, there are a lot of things that I'm not also going to favor that would probably create a grand compromise. I think the better solution there is to say, well then look, if that's the cost, if we're gonna have these big losses on both sides, fine. Congress working is Congress not reaching those compromises and instead saying, let's work this out in the states. Let's do the things we can do. We're going to make sure we take care of national defense. There are certain national priorities that need to be handled nationally. And then most of the other fights need to be happening on the state level. And so I think the filibuster keeps us in a position where we are raising the cost of nationally mandated solutions, supposed solutions for everything that are intolerable to a whole lot of us to have to live under, and allow us to say, look, let's have the differences state to state.
I'll just put it in a more crass, practical way. The Democratic Party has a huge laundry list of legislative priorities. The Republican Party does not.
Yeah.
So if you get rid of the filibuster and enact everything both parties want, that is a net negative, and it's not even close.
I 100% agree. I mean, right now, you go through the I mean, most of us know the names and titles of bills that Democrats want done that they have drafted and ready to go as soon as there's no filibuster, right? The whole Women's Health Protection Act, right? That's the National Abortion Act. Like, there is a title to that bill that's ready to go. The Republican strategy seems to be, let's pass the SAVE Act, and then we will begin the process of a conversation about maybe doing something on permitting reform, right? So just from all the principled reasons why this is a bad idea, would you just look at the stack of pieces of legislation that Democrats have ready to go that they've tried to get passed in the past, single-payer health care and everything else, and Republicans would be, again, divided about how much more divided than Democrats about how we want to, what exactly should be done on some specific questions. I think that's frankly to the advantage of the Republican coalition, that there is more diversity in terms of how to approach certain questions. But we would there's a much smaller list of things, right? We're not talking about the national piece of the piece of legislation that reduces the size and scope of the federal government, right? That set of bills is still has not actually been drafted. We're not ready to go with that. And so I think it's a net win for Democrats.
If we could have Charlie as parliamentary czar, then sure, get rid of the filibuster. But otherwise, you convert it into that, and it becomes effectively a parliamentary system. A one-seat majority gets you 7 prime ministers in 10 years.
So what about adding states? We're in Washington, D.C. The license plate complains about lack of representation. America has added states in the past, added Hawaii and Alaska last time around. America has added states in the past in the hope, at least on the part of those who were in charge of adding them, that those states would end up voting the right way, which has kind of worked out if you look at the Mountain West. So what is the good argument against the Democrats coming in 2029? They win the House, they win the Senate, they win the presidency, and then they add Washington, D.C., which is really put upon and lacks representation, and they add Puerto Rico or what else? Why is that bad?
Well, in our history, states were generally added for kind of non-partisan reasons or with partisan balancing. You let in one of these and one of those. And sometimes the partisanship resonates in different ways, a slave state and a non-slave and a free state and what have you. This would be for specifically partisan reasons. In D.C.'s case, there's its own special history. The federal capital was never meant to be its own state, and frankly, the optimal solution for no taxation without representation is no taxation, and then people flood in. I wrote an op-ed to that effect 15 years when I lived in D.C. I'm happy not being represented if I also have no taxation, or retroceding to Maryland. Of course, Maryland doesn't want it. Lots of other complications. Then you just have kind of a rump strip of the federal land. Puerto Rico also, there's not clear that a majority there. They have multiple plebiscites and referenda and polls and what have you, and there's never been a majority for statehood. So what, you're going to just drag them kicking and screaming or bribe them, or I don't know, it doesn't make sense. It's a separate conversation to say have some sort of balance. Maybe there should be 4 states in California, 4 in Texas, 3 in Florida. Who knows? That's a different kind of technocratic discussion perhaps, but just adding states purely for partisan reasons again becomes an illegitimate exercise.
Yeah, I think this is all part. It's the same problem, right? People have run into a wall in terms of their ability to get sort of a fringe partisan majority wanting to get, or minority wanting to get things done that they feel like the current structure doesn't permit them to do. And so you're looking for these enormous, you have 2 choices there, right? You can either say, okay, well, maybe we need to change our expectations and or build some other coalitions to help us try to get these things done, right? That's called politics. It's called attempting to win elections. Or you can take the strategy that is, well, the system has to completely be altered, right? And so, there's nothing fundamentally wrong with adding states. It probably is, will likely be the case that at some point the United States will end up adding states if the republic continues. and Puerto Rico is a perfectly good candidate. I think it makes sense to think about when Puerto Rico is ready to become a state. I think that is something that's entirely plausible. The problem is when you're pursuing those types of strategies as a replacement for actually being able to persuade and win elections and moderate your positions as necessary in order to win elections. And instead are just trying to hold on to sort of these fringe positions and still be able to gain the power to be able to make it happen. And like Ilya said, I mean, essentially, this would be sort of like with court packing. You have we'll add seats and then you'll add seats. East Dakota suddenly looks like an enticing possibility. I mean, this is where we'd be, right? This is where we'd be. I don't think that's sort of a long-term good solution for the country.
And this is sometimes discussed in terms of having more senators, but also there's obviously a knock-on effect on the Electoral College, which if we don't get rid of it, which is a whole other thing that they're demanding from the rabid left, the best solution for fixing some of the disparities in Electoral College representation, which would have positive knock-on effects for accountability and representation and closeness to the people, would be simply to expand the size of the House. The House has been fixed at its number for about 100 years at this point. Used to be growing with the country. If it kept pace, that would be a lot better. It would fix gerrymandering, because harder to gerrymander, districts of 70,000 rather than 700,000 people. Fix the disparities in Electoral College. Lots of other salubrious developments there.
I think we need to get creative and have a counter proposal that will shrink the Supreme Court and kick some states out, and then maybe we'll come to a compromise where we keep 9 and we keep the 50, right? Okay, I think we probably have time for one question.
Hi, thank you so much for the talk today. First, in regards to the Filibuster Appreciation Club, how do I join? And the second was in regards to the filibuster itself. The filibuster is a very unique check on the power of the Senate in the sense that it completely relies on the goodwill of both sides. There's nothing in the Supreme Court or in the Constitution that requires it. And so how do we know that going into a Democratic majority in 2026 or 2028 that they will not just destroy the filibuster irregardless of what Republicans do now?
Casey, I'm going to give you that because you touched on this.
Yeah, I think the short answer is we do not. We don't. We can't know. I would still probably guess that it's less than 50%, mostly because I think Democrats wouldn't hold that large of a majority even because structurally they're in a difficult place with the states, which is why they want to add the states. But I think it's unlikely that they there's a decent possibility that they would. We certainly can't bank on them not. I think it's still a bad idea for Republicans to do it. I mean, look at the recent history of the filibuster is basically Democrats deciding to eliminate the filibuster on
Mitch McConnell warning them not to, them doing it, and it bites them.
And the result is a 6-3 Supreme Court. And so I do not want to be on the side of the people who tore down the filibuster, especially as we said, it's not as if there's a nice big stack of constitutional republic restoring legislation that Republicans are ready to pass. I think it would be a foolhardy move.
I would just say very briefly on this that I actually think the filibuster might be the one thing keeping us all together at the moment, and this builds on something Casey said, that when you abolish the filibuster for judges, as was done in 2013, you're removing a check that if it isn't there would lead to there being no judges, and that is a problem. But if you abolish the filibuster for legislation, then you're pushing legislative energy up to the federal government rather than keeping it at the state level. And I really do believe, given how cross everyone is with each other in America, that the best thing we have going for us is federalism in the states. I mean, I live in Florida. I love Florida. It has the policies that I like. I also have good friends who live in Massachusetts, and they love Massachusetts, and I'm totally happy with that. I don't resent them for living in Massachusetts. I might resent them if they got their own way at the federal federal level and destroyed what Florida is. So leaving aside the fact that I'm a conservative, I want conservative outcomes. Just as a country, I really do think that we are benefiting from the filibuster being there in a way that perhaps those who want to get rid of it don't appreciate. Because if one side comes in, rides roughshod, gets its whole agenda through, I think people are going to get a lot more angry.
I think even just from think economically, right? I don't think people appreciate that we've sort of settled into a place where what your tax rates are if you decide to build a business, you sort of expect them to fluctuate about like this, right? Because it's about what you can change in Congress at this point. You don't expect them to change from a Bernie Sanders-driven budget, to a Republican budget. You don't expect it'll be somewhere between a 20% tax and a 70% tax. That's where you could be, right? And that's not just a problem for you have to worry about the possibility of the 70% tax. Things just don't get built. People just decide not to invest because I don't know what's happening 3 years from now. And if I don't have that sort of certainty, it doesn't make sense for me to break
Part of the rule
ground.
of law is stability so people can plan their lives.
Right.
I think one more question.
So one thing that came up were a few modest proposals. So one other modest proposal I've heard is the one proffered by Glenn Reynolds. He's a law professor at the University of Tennessee, and that would be for increasing the size of the Supreme Court, but not on a partisan basis, just doing it over time. And the overall effect would be that each individual justice would be sort of less of a philosopher king. There would be more of them. There would be less attention paid to each individual. Is that something that you feel is a good idea, or is it just sort of like the well has been so poisoned on this topic that there's no doing it in a nonpartisan way?
I'll take this one because I wrote about it in my book, Supreme Disorder. Look, if we were writing on a blank slate, if we were the founders creating a new constitution, there's plenty of arguments for how we would structure the judiciary or the Supreme Court or any of these things somewhat differently. But we're not. And there are transition problems. There are issues of, okay, what's our optimal number? We'll go to 15, or maybe we should go to 14. Some countries have an even number, and then you have to have a margin of 2 to do anything. Anyway, we figure out what the number we want to get to, and then what? We add a justice every 2 years. Who would agree to that, given politicians are short-sighted in terms of the horizon of when they're in power and all that? What about the current justices? Are we adding term limits at the same time? When do the vacancies arise? Lots and lots of different complications, which have further second and third order effects. So I think Glenn is speaking right from a matter of kind of abstract first principles, but you can't get there from here.
It's also just worth saying, there is not a problem with the Supreme Court. There is no crisis. There is nothing that needs fixing. What has happened is that there have been some decisions that loud people don't like. And that for the first time in about 100 years, you have a consistently constitutionalist majority on the court. That's the problem. I think this is just so interesting, is that the presumption that you read every day in the newspaper is, well, what are we going to do about the Supreme Court? Nothing. There is nothing to fix here as far as I'm concerned.
We could do that.
Yeah, so...
I mean, whether you're talking racial preferences in higher admissions, whether you're talking, biological males and women's sports. You can go down the line. These are popular opinions. Dobbs is about 50-50. There's very few underwater opinions. Presidential immunity might have been one. Chevron doesn't get polled because nobody can understand that, of course. But generally, all these so-called controversial, legitimacy-destroying decisions simply are not if you're asking the public.
All right. Well, that is unfortunately all we have time for. So thank you to Ilya and to Casey.
Ladies and gentlemen, we're going to take a super quick 5-minute break. The program, we've saved one of the most accomplished advocates ever to stand before the Supreme Court. Paul Clement, a former U.S. Solicitor General, has argued more cases before the court than any lawyer of his generation. He'll be in conversation with my colleague Ramesh Ponnuru It hasn't been announced yet, but Ramesh has just been cast in a prequel to the Odyssey, the Iliad. He'll be playing Helen of Troy. So congratulations, Ramesh, and please join me in welcoming Paul Clement and Ramesh Panuru.
Thank you, Phil. I'll find some occasion to get even. Phil left off one of your great distinctions, which I think you are one of only 2 people in U.S. history to have lost a job for winning a Supreme Court case, along with your partner at Clement and Murphy, Aaron Murphy. So that should get in the Guinness Book sometime. I wanted to start by picking up on a remark that Charlie made in our last panel, where he said, this is the most consistently constitutionalist majority we've had on a Supreme Court in 100 years. Do you share that assessment?
Oh, I definitely share that assessment, and it really is a remarkable court. And if you sort of think back to when I started my career arguing cases in front of the Supreme Court, thanks to General Ashcroft, I was facing a court where the only way that you could get to a conservative, which in most cases is synonymous with a constitutional outcome, was to get both Justice O'Connor and Justice Kennedy to agree with you. You sort of had, kind of 3 votes that you thought would be with you, and then you really had to run that gauntlet of Justice O'Connor and Justice Kennedy. And that was exceptionally difficult to do. And, you think now where you have a 6-justice majority on many issues, and really fundamental issues of constitutional law in the purest sense, and that is a remarkable change. And then if you do think back kind of historically, I think you'd have to go back 100 years to have a court like this.
As an advocate, one of the things that I think follows from that is that you used to have this kind of swing justice model of the court, where many briefs would be written really as Kennedy briefs. Whereas now it seems to me that you've got these 3 groups of 3. We could call them the originalists, the institutionalists, and the liberals. How does that affect how you approach your work?
Sure. So, I always think that a good working definition of a Supreme Court advocate is somebody who's trying to get to 5 for their client. Because, my clients, if you get them a pure, beautiful, originalist opinion joined by 4 justices, my clients have a word for that. They call it a loss. So you really are trying to get to 5, trying to get in the win column. And as we were alluding to, when I started practice, that required sort of Scalia, Thomas, Rehnquist, and then Kennedy and O'Connor, and it really was all the focus being on Kennedy and O'Connor. And then for a while it was a 4-1-4 court, and after Justice O'Connor left, and then all the focus was on Justice Kennedy. And you had some of these, remarkable opinions. I argued a case called Rapanos when I was in the government, and 8 justices fundamentally disagreed with the test that Justice Kennedy articulated and said it was impossible to apply in practice. But that was the law of the land, thanks to Justice Kennedy, because it was a 4-1-4 resolution in a 4-1-4 court. And now the job of getting to 5 really starts with, okay, I'm probably going to get either the 3 liberals or the 3 conservatives. And I really need to think about how to attract the 3 kind of more institutional minded justices to my side of the case. And sometimes that's pretty straightforward. There's some issues where there really isn't any delta between the institutional conservatives and what you might think of as the originalist conservatives. But then there are other cases where there's a pretty significant difference.
Justice Barrett, of course, has been a real flashpoint, which is, I think in some ways a little mysterious, actually, why she's become such an object of controversy even among people who are friendly with us, people who are large, or in some sense on the right. What do you make of her jurisprudence so far?
So, I'm not going to, as somebody who argued a case last term that I lost 5-4 and think I should have won at least 5-4 and maybe 6-3, I'm not going to say that that Justice Barrett hasn't made any mistakes.
The Watson.
That would be the Watson case. I do think there is an election day and not an election month. So I do, and I think there was a strong originalist, textualist argument for that. So I'll be the first to say I think she got that one wrong. But in general, I think she's a very strong justice, and I think she is a justice in the mold of the justice that she and I both clerked for, Justice Scalia. And so, at the same time that the Watson opinion sort of disappoints me, I can point to other opinions where she wrote a strongly textualist opinion that was pretty fearless. There are other issues where she's been willing to go further than her fellow Trump appointees. And of course, I don't, you can't attack Justice Barrett from the right without forgetting about the Dobbs opinion. And so, I think, maybe some people, on the right, have gotten so used to winning so quickly, because it was a long march through the desert. I mean, having clerked for Justice Scalia, I can tell you how disappointed he was at the end of a lot of the terms on which he served as a justice, where he felt like he was in dissent on everything he cared about. And, I'm sure Justice Thomas felt the same way. And so, I think it's a mistake to take winning for granted. And I think it would be a mistake to be too critical of Justice Barrett.
So there are legitimate criticisms, but she's not an embarrassment to her family, as the president described her.
Yeah, no, and look, there's a broader point here, which is it is always fair to disagree with justices on particular decisions and to articulate your disagreement in civil but forceful tones. I mean, that, the justices are sufficiently insulated that that kind of fair criticism, I think, is actually critically important for the whole system. But there is a difference between that and kind of personal attacks. And I do think, you really, and you've seen this over the past couple of years, but some of the attacks, mostly from the left, but occasionally from the right, of the court that really question the institutional legitimacy of the court. I mean, I think those are something that, is new over the last, let's say, 5 years, and I think is pretty problematic.
You were, if I remember correctly, you were on one of the short lists that President Trump put out for the Supreme Court during his first campaign. Now that you've represented several clients who are taking on the administration or disagreeing with administration policies, do you think you're still on that list?
Well, let me say two things. First of all, I think it was a pretty long short list, so I wouldn't take it too seriously. And I'd be surprised, no matter how long it is, if I'm still on that one. But I think you sort of have to look at it from the perspective that ever since I've left the executive branch, where I feel very privileged to have been able to serve, and I spent almost 8 years defending executive branch agency action. But it's now been 18 years since I left the department, and I've spent the last 18 years challenging executive action as being either inconsistent with the Administrative Procedure Act or the Constitution or the structure of our government. And I never planned to take an administration off and just say, oh, well, this administration, I'm not going to challenge anything that strikes me as being fair game to say it's executive branch overreach. And I think one of the most interesting opinions written this term, frankly, was Justice Gorsuch's concurrence in the Slaughter case. And the Slaughter case is the case where Humphrey's executor went the way of Humphrey, and the court finally overruled Humphrey's executor. And I think from the perspective of kind of constitutional conservatives, I mean, that overruling is, really as consequential as the overruling of Roe. Because if you care about the structure of our government, the framers were quite emphatic that we have 3 branches of government, not 4. And Humphreys has always been in considerable tension with the notion that like if people in executive branch agencies are doing anything that's legitimate, they must be exercising executive power. It's certainly not exercising legislative power. They're not exercising judicial power. So it must be executive power that they're exercising, and therefore it's only logical that the president, who is the source of their only authority, would be able to remove them. And so I think that decision is hugely important from a structural constitutional perspective. But what made, I think, Justice Gorsuch's kind of opinion so important is he sort of admitted, the dissent made this point that, well, Congress wouldn't have given all this power to all these executive branch agencies if it knew that the president would have absolute control over them. And Justice Gorsuch in this concurrence basically spots the dissent that argument and says, you're probably right. Congress wouldn't have given this much authority to the president if they knew that's exactly what they were doing. And he essentially says, and that makes it all the more important to use the tools available to put appropriate checks on executive power. And so, I think, from my perspective, I'm a big believer in the unitary executive, but that doesn't mean that the president gets to do anything he wants. It makes kind of the constraints, the other constraints on the executive to sort of, behave within the constitutional limits, to comply with the Administrative Procedures Act. That almost makes them more important. Now we know who's responsible. The president's responsible. You can't impose burdens on the people and avoid responsibility from them with some fuzzy notion that, well, that's the Federal Trade Commission. Well, whoever voted for the Federal Trade Commission? Never, anyone, no one. You vote for the president has responsibility, but he needs to be accountable both to the people, but also to the Constitution and to kind of coloring within the lines when it comes to legal authority.
Well, it seems like this blow for the unitary executive would naturally pair, especially given Justice Gorsuch's concerns, with a stronger non-delegation doctrine. Do you think that there's any prospect for that on this very structure-oriented court?
So I think you're right, and I mean, if one way to read Justice Gorsuch's concurrence is just a plea to revive the non-delegation doctrine. I think it's more than that, though, and it's not limited to the non-delegation doctrine, and he articulates a number of tools that are available to the courts, and then he also, of course, lays down the challenge for Congress to kind of wake up and do something. We can talk about that in a minute. But I do think, in his mind, the non-delegation doctrine is a big part of the solution. And I do think he has to be right. Now, I also think it's one of the great challenges kind of facing conservative lawyers kind of in this, coming decade, right? Because, Justice Scalia was, kind of famously against delegation. He sort of said any delegation of legislative power to the executive is per se unconstitutional. So it's not a matter of excessive delegation. Any delegation is problematic. But as much as Justice Scalia thought that, he kind of despaired of having a workable test. And of course, like the one thing Justice Scalia was as fearful about as kind of delegation was, Article III judges running amok and just kind of making it up case by case without any administrable doctrine. So I think the great challenge in non-delegation is to come up with a test that puts limits that don't just empower the judiciary to kind of call balls and strikes without telling us what the strike zone is.
So much of what we talk about in politics and law has at least as a background assumption that Congress isn't going to do anything, and that Congress is not the first branch, but in terms of its actual power nowadays, the weakest. The courts can do all kinds of things to say, Congress needs to pass more specific laws, for example. But how do we actually get Congress to be Congress? How does it exercise that power?
So it's a real challenge, but just to kind of make it as clear as I can, I think it's not a challenge you can just throw up your hands at and say, yeah, it'd be great if Congress did something, but we've been saying that for a couple of decades now, and it's just hopeless. And the reason I feel very strongly that we can't just give up on this is our Constitution is designed to check a powerful Congress. I mean, that is the structure of the document. I mean, Madison said famously that it's Congress that's the impetuous vortex, not that it's the executive branch that's the impetuous vortex, or that the real danger here is, overbroad executive orders, and we have to structure our whole Constitution to keep the executive branch in check. It really is designed to put, checks on a strong Congress. And so if you have the world we're in right now where Congress is weak, and you see this every day, that the most controversial issues in society are being pushed from Congress to the executive branch and the judiciary, and that's just not the Constitution that we have. I mean, nobody would design there's this push right now for like term limits on the Supreme Court. And, I think part of the impetus for that is where we are right now, because no one would design a system where, we have, a bicameral legislature, and we have the representatives elected one way and the senators elected a different way. And then there's, kind of the veto and all of that. And then, oh yeah, we do all of that, and then all the hard issues are going to be decided by 9 unelected people. Like, nobody designs a constitution that way. So we really need to do something to revive the legislative branch and make it more vibrant. And there are a lot of things that maybe could be done in that. I think we all have to sort of focus on that. I will say, and I think Casey was here earlier, but we did do, I think one important thing in getting Chevron overruled in the Loper-Bright case, because I do think that was a big part of the problem. Because if at any given point you're sitting in Congress and you can either, let's see, compromise on some legislation that's going to get you a primary challenge and get you a lot of, sort of gruff from your constituents, or you can get exactly what you want by calling up your buddies in the executive branch and having them just do it by executive order or rule. Like, what rational person would say, yeah, I'm gonna forge a compromise with these people across the aisle who I don't even like very much, and then get challenged in the primary? Like, the incentive structure under Chevron was all wrong. There was no good incentive, no good reason to legislate. So I do think getting rid of the Chevron doctrine, it's not a panacea. It's not going to solve anything alone or overnight. But I actually think that was a critical part of kind of lighting a fire under Congress again.
On the separation of powers questions, you mentioned Slaughter, and of course Cook also came down. And I was wondering, there was arguably highly related cases, how whether that complicated the job of making, because you didn't have a decision in Slaughter, but at the same time Cook is being argued.
Yeah, I mean, Cook could have been a narrower decision than it was. And the thing that some people lose sight of in the Cook case is that the executive branch proceeded very differently in the Cook case. And maybe I should be more
Federal Reserve.
Yeah, the Federal Reserve. And with respect to essentially all the other sort of, let's call them quasi-independent agencies, not because that means anything, but because it's a useful way to identify the alphabet soup agencies that were kind of at issue in Slaughter. With respect to all those other quasi-independent agencies, the president came in and he just fired people, and he refused to give a cause. Said, I don't need to under the Constitution, or my view of the Constitution, I don't need to give a reason why I'm removing a Democratic FTC commissioner. And that's how the issues got teed up in all those other cases. So the constitutional issue of whether the removal restrictions that Congress tried to put on those positions was front and center in all those other cases. But the president didn't proceed that way with respect to the Federal Reserve Board. And there he essentially asserted that he had cause to remove Governor Cook. And so he didn't tee up the constitutionality of the for-cause removal restriction on the Federal Reserve Board. But the court decided it anyways. And I think that's probably why the decision ended up being 5-4 at the end of the day. And, so I think there was a way to decide that case that would have just, left for another day the constitutionality of the for-cause removal restriction on Federal Reserve Board governors and just said, like, right here, that's not challenged. And the president didn't give sufficient sort of notice and an opportunity for hearing in this particular removal, which in some ways is what the court held, but they went on, a majority of the court, to essentially decide the $64,000 question, not adjusted for inflation, about the Fed's constitutionality. And so I guess that's just a long way of saying the decisions end up being kind of more in tension than they probably needed to be. And then, I think we're left with a result where, because of its historical tradition, the court has decided the Fed is just fundamentally different. But as important as that decision about the Fed is, I still think, Slaughter is kind of the headline case because it's a very different world to have, all of these agencies directly responsive to the president. And as Justice Gorsuch pointed to, I think it's going to take, years to sort out all of the ramifications of the Slaughter decision, because we have, there's a whole architecture of administrative law that's basically premised on the notion that those quasi-independent agencies are different from a typical executive branch cabinet official agency. And just to pick one, but I've already in my own practice come across probably half a dozen of these. But there's a whole bunch of DC Circuit case law that says that when an agency like the FCC is adjudicating a matter, they have to have an air of impartiality, and they have to not pre-decide the issue. Well, how does that work in a world where the FCC commissioners are directly responsive to the president, and the president has already put on Truth Social how he wants the issue to come out? It doesn't make sense to say, well, everybody in the agency who's directly responsive to the president now has to recuse. And so I think it's going to take a good half decade, maybe a decade, to kind of sort through all of the implications of Slaughter.
Always thinking of future cases.
Got to do that. Got to do that. Looking forward.
You talked about, and many of our speakers today have talked about, the last 5 years of attacks on the legitimacy of the court and these more and more radical proposals of what to do about the Supreme Court. Some of the legislation on term limits, for example, and you were just mentioning term limits, presumes you can do that by statute. You don't even need a constitutional amendment to do that. I'm just wondering, are we losing as a culture, even if we're making all these victories at the Supreme Court, in the federal courts, are we losing the cultural foundations of the rule of law in our country? And what should people who are concerned about the rule of law, or people who have an institutional interest, like law firms or the bar, law schools, what should they be doing to counter this? Of course, in some cases, they should just cease and desist what they're doing.
Right. Yeah. No, that's the easiest thing. First thing, do no harm. But I do think lawyers do have a special responsibility to kind of speak up for the institutional legitimacy of the court. And as I've already alluded to, that doesn't mean you don't criticize them. But you criticize them fairly and in a way that doesn't call into question the basic legitimacy of the institution. So I think that's something where there is kind of the special responsibility to step up. But then, at some level, there is, this gets back to the conversation about trying to revive Congress. Part of the questions about the institutional legitimacy of the court, the language may be unfair, but what, some of the root of some of the criticism is this notion that the court right now is deciding, most of the most contentious issues in our country. And you can't expect 9 unelected people to decide some of the most contentious issues in the country without there being some pushback on that. And the reason there's something kind of off here is because we've kind of drifted from the framers' design. And, if you imagine a world where the Supreme Court is, mostly deciding ERISA and bankruptcy cases, like nobody cares that much about the Supreme Court. Nobody's talking about term limits. Nobody's talking about even more radical, efforts to pack the court or the rest. And so I do think, we need, in the long run, to sort of take the temperature down on the court. And the only real way to do that is to get Congress to step up and tackle some of these more contentious issues itself. Because, the system's designed to allow people, when they don't like the substantive results on contentious issues, to vote the bums out. And there's no way to do that with the Supreme Court. And so if the Supreme Court keeps on deciding all of the most contentious issues, it's going to create a lot of pressure to have kind of criticism kind of go above and beyond the bounds.
So we have time for a couple of questions. I can't resist, though, mentioning that I once had the opportunity to introduce the late, great Justice Scalia when he was giving a speech. And at the end of his speech, he said words that I'll always remember. He said, "I will now take your questions. Notice I did not say I will now answer your questions."
That sounds like my old boss.
So, as you pointed out, the overturning of Humphrey's executors fundamentally changed the role of executive branch agencies. What do you think of the idea that was championed a few years ago by Paul Ryan and other Republicans for a requirement, perhaps even a constitutional requirement, that major new federal regulations be approved by Congress instead of simply dictated by the bureaucracy?
The REINS Act.
Yeah, no, I mean, I think that is what I would think of is like, that seems like a reasonable second best option, which is, if we're not going to, like, there's a way for Congress to kind of, have a hand on new major regulation, and it's called, bicameralism and presentment, right? They're actually supposed to legislate, and then you don't have to, like, worry about this. And if you had a revived kind of non-delegation doctrine, you might not have that many kind of major new rules emerging from the executive branch. So, I'd like to go to, a world where, really all of the new major regulatory initiatives, if any, are coming from Congress. But if you can't get there, then I think something like that kind of, changes the impetus a little bit. And so, if somebody's going to benefit from legislative inertia, why not the citizens and having them less regulated as opposed to letting the entity that always benefits from legislative inertia being the executive and executive power?
Other questions? I think if you've seen oral arguments, heard oral arguments, you won't catch them flat-footed. Yes, another one back there.
You emphasize how wonderful the current court is in deciding the issues that come before it, but I think one thing we're all generally noticing is that the number of cases actually coming before it seem to be shrinking more and more. I worry that in 40 years we'll be waiting with bated breath on what 3 or 4 cases will be deciding that term. Do you think there's anything that can be done to try to encourage the wonderful court that we have to decide more things?
Well, I mean, I've done my part by trying to urge them to take more cases. So far, unsuccessfully. But I actually, I'll say 2 things. One is, look, one thing Congress could do, in a way that doesn't require a constitutional amendment is to restore some additional areas of mandatory jurisdiction. And, because the court need not decide 60 cases a term. That is really a historically low number. When I was a law clerk, they were deciding 100 cases a term, and people were complaining that they were slacking off because just a few years before that, they were deciding 150 cases a term. So, we're at something like kind of 40% of capacity. Now, like some of that is, when when you're the Warren Court or the Burger Court and you're inventing new constitutional rights every day, that's so much fun. Like, you want to take lots and lots of cases. And if you're just simply restoring the constitutional order, that's something that maybe doesn't require quite as many cases. But I actually think the current court is making a mistake by taking only 60 cases, because every term there's going to be somewhere between sort of, let's say, a half dozen and a dozen cases that are very contentious on divisive issues. And, right now people look at the court and they say, well, almost all the court does is decide these divisive issues. And they sort of have a point, because it's like 10 or 20% of the court's docket. And, I think if the court took, 100 cases again and took a few more ERISA and bankruptcy cases, or, there's this idea that, the Supreme Court of the United States doesn't take cases merely to correct error. They take cases to resolve circuit splits and that sort of thing. And my view is, what's wrong with a little error correction? If there's a case where some, court has required a class action that's going to bankrupt a company and it doesn't make any sense to have a class action, why not take that and reverse it? If there's a case where some jury in, one jury pool somewhere in the country has whacked a company with $100 million, in punitive damages, or $1 billion in punitive damages, why not take that case and reverse it? And it doesn't even have to be left-right. If we're going to have if there's the court wants to take a capital case, or they see somebody in a non-capital case who gets a very unfair sentence, take the case and reverse it. Two things will happen. One, the court will, I think, be unanimous in those cases if they really are correcting error, and that has some virtues to have the American people look and say, all right, like, this Supreme Court is doing something other than the other branches of government, because I know some of them are liberals and some of conservatives, but on a lot of these issues they agree. And then the second thing it will do is, people will look at the court and they won't think, all right, that's the entity in the government that does kind of, race, abortion, and whatever else is super controversial. They'll be like, yeah, they do a lot of stuff. Most of it is boring. And, that's actually what the framers designed the court to be. So I do think taking more cases would be an affirmative good thing, not just because it would help my practice.
All right, I hope you'll all join me in thanking Paul Clement for giving us some of his valuable time.
Well, that concludes our program for this evening, or this morning. If you could join me in giving all of our speakers, I think we have an amazing group of leaders and public servants who really came and gave us a substantive discussion today. Very grateful to everyone that joined us. Let me also give a thanks to our sponsors, again, the Peter and Judy Kopsis Foundation, as well as Dale and Wendy Brott. Without their support, none of this would be possible. I just also want to highlight a couple of the other events that we have going on. As I mentioned at the beginning, we have our Lasting Liberty and Prosperity series throughout the year of 2026. Our next one will be in San Francisco, highlighting American innovation on August 26th. We'll be in Nashville, highlighting the moral bedrocks in America's founding on September 24th. And then, of course, we have the William F. Buckley Prize Dinner in New York on October 29, where we'll be honoring Joe Lonsdale and Steve Forbes. It's going to be a very special night, and I hope you all are able to join us. If you want to learn more about the work of National Review and you want to learn more about how you could be supportive of it, I also want to point out Noel Carter with our gift officer team, and Jack Pura, who is over there. So again, thank you so much for all of the time that you spent with us. We'll be posting this online on our YouTube channel, so highly recommend you come back and revisit some of the discussion that we've had today. Thank you so much.